Maybe I beg to item number 21 and 36. In 21, we have taken the consent. For the 1 and 5, I'm taking time because my junior has gone to Calcutta, my lord, R&T for transplant of
Item number?
21.
What do you want?
All the time, it is 2 weeks time, my lord, because my junior has gone to Calcutta with her brother for kidney transplant of her brother.
So,
Because the brief was with her and she left urgently because the brother condition was very bad. Both the kidney were damaged.
Mr. Sharma, kindly don't mind, but is it befitting for a senior counsel to mention that aspect of the matter?
But
It is not befitting.
yes,
I would consider that you have not made that mention. We'll see when the matter reaches. Yes,
and same is my item 36 also.
I'm not going to hear that. That the junior counsel forgot to brief the senior counsel, and the senior counsel doesn't have the brief, so the senior counsel mentions. This is not befitting of a senior.
Of course, madam. But suddenly she had to leave.
Sorry, I'm not going to take note of such requests.
My please, Your Lordship. These two matters, Your Lordship, pertain to settlement of market, Your Lordship. It was fixed on 10, but on 10th it has not been listed, Your Lordship. 10th of November it was fixed, but
I fixed it.
it was not listed on 10th, Your Lordship.
Matter was fixed.
Yes. On
We'll have it tomorrow then.
May I please, Your Lordship? Lordship, yesterday, Your Lordship permitted me to list it a motion matter relating to tender, Lordship.
Motion.
Motion matter.
Then
Your Lordship permitted me yesterday to be listed today, Lordship. Even the case is numbered also, but it was not listed. May I pray for
you want the matter to be listed today.
Lordship?
May please, Your Lordship. Lordship, with regard to item number 13, Lordship, the grievance of the petitioner has been sorted, Lordship. The matter has become influxed.
Mr. P. Bodloy, the learned counsel appearing on behalf of the petitioner, admits that the writ petition has become infructuous in view of the fact that the petitioner's grievances have been duly redressed during the pendency of the writ petition.
Lordship.
He therefore submits that the petitioner would not like to further proceed.
Lordship.
Mr. G. Bokel, you appears for the fishery department. Huh? Fishery also, government now appears for the fishery department of the government of Assam. Taking into account the above, the writ petition therefore stands closed as it has become infructuous.
Oblige, Your Lordship.
Interim orders, if any, stand fixed.
Oblige, Your Lordship.
My lord, this matter relates to settlement of GHAT, my lord. May be listed for admission on 14th, my lord.
Admission? Where?
Here, there is no interim order. Here, notice was issued, my lord.
When was the notice issued, making it returnable?
26/9, my lord. 26/9, and we are supposed to file one additional affidavit by correcting the name of the GHAT. That also we have done, my lord.
19.
Application is for order. Petitioner to internship at hospital authority are not allowed.
Order. Bench matter. Okay, 1st of December.
Lordship, with regard to item number 2, Lordship, the SPS construction matter, Lordship, we have decided to move an appeal, Lordship, against the order in the IA, Your Lordship. Lordship may kindly adjourn the matter for the day, Your Lordship.
Mr. N. Gautam, appearing on behalf of the petitioner, submits that he requires some time at 6 for an accommodation. List this matter on 19th of November.
Oblige.
Here there is a mention of the item number 2 to 19th of November.
Supplementary item 58 as a first item for hearing.
Yes, what is the matter about?
My lord, I had a fair price top license, man. that has been cancelled by the impugned order, that lordship may kindly see page 37. Here, my lord, they issued a show cause notice to me that lordship may kindly see page 16. And thereafter I replied, they had made certain exercise list. On the basis of a complaint filed by some persons, inquiry was conducted, but copy of the complaint petition was not furnished to me. And thereafter, matter was inquired into as per their own version. Matter was inquired into, but inquiry report is not furnished to me. All were done behind my back. So, my lord, our High Court had two decisions, several decisions that they have produced two decisions that is there already in record. That is, one is Kiran Bora.
Where is your reply to the show cause?
They have filed reply. In reply, my lord, they have filed the complaint petition.
No,
They have
where is
annexed
your-
the-
where is your reply to the notice dated 16th
Yes,
November?
that lordship may kindly see page 20.
Why didn't
And
you
my
ask for,
lord,
why didn't you ask for the inquiry report?
My lord,
Why didn't you ask for your inquiry report in your reply?
that was not asked for because that is the mandatory duty of the other party.
No.
Should have,
You see, if you are seeking violation of the principles of natural justice, the question comes as regards prejudice. Now, the question is prejudice, if it comes, you should have asked for that.
that was not asked for, but my lord, one thing, all my consumers have filed petition before them, before the authority, that he is distributing the materials regularly, we are getting everything. Some unknown person filed complaint, and on the basis of that inquiry was held behind my back. And my lord, that public petition in my favor may kindly be seen, page 24. Here, my lord, 141, who are my consumers, they have supported that I have done well. I have never done any malpractice or in distributing the materials. So I don't know who are the persons who filed complaints. So I remain in darkness. Who are the persons, whether they are my consumer or not. So my lord, our High Court has said that if the complaint petition, who filed complaint against the person concerned is not furnished, nor the inquiry report is not furnished, nor at the time of inquiry he was heard, at that time the order was set aside by. That
Is-
judgments I
The
have,
complaint is there in the affidavit.
in their affidavit it is there.
Then,
No, it is afterward. It is after cancellation of the
but you should have
license.
asked, what is the complaint?
Complaint is, they have filed in their affidavit, they have annexed it. But when the license was cancelled, at that time it was not with me. After much later, they have produced that. So I got no chance to reply according to their complaint. So my lord,
Now you have this complaint.
Yes,
That is your grievance.
yes.
Let this remain as it is. Yeah, we set aside the cancellation and then put you under suspension. You submit within 10 days or 15 days, you have it, and they will decide on the basis of that and then pass an order. That's the only thing can happen. You cannot, you see, the allegation against you is very serious.
Maybe, my lord.
So this is what has been given. So they will decide on the basis thereof. Therefore, your basic ground is that you have not been provided the complaint as well as the inquiry report. Now, these are part of your affidavit.
Yes.
So on the basis of that, you submit your representation, as a reply to that show cause notice. And on the basis therefore, they will decide within a period of 60 days from the date you have submit.
Some more time because I have to collect the data of those persons. Who are those persons?
Okay, you,
30
no,
days.
from the date you submit.
Yeah.
From the date you submit, if you, I give you 30 days for you to submit. And if you don't submit, this order which has been said about cancellation will revive. And if you submit, they will consider and dispose of within 60 days. Matter over. See, Mr. Mahmood have been trying all his best to get the matter done from such a long. Heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner. Ms. B. Bhuiyan appears on behalf, the learned senior counsel appears on behalf of the respondent numbers 2 to 6. 2 to 6. Mr. B. Bukel appears for the respondent number 1. Hmm? All these things you appear. This food and civil supplies is the transferred subject.
Yes, their subject. No, accepting law and order, all are with you.
The petitioner herein have assailed the order dated 16/1/2025, whereby the respondent number 5 had cancelled the retail PDS license number GSM-8/2015/32 issued to the petitioner on the ground stated or for the reasons categorically stated in the order date stated in the order. Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has been filed on the ground of violation of the principles of natural justice, inasmuch as the so-called notice which was issued on
Because 16/11/24.
16/11/2024 was based upon certain complaints and complaints made by the beneficiaries and report.
Alleged beneficiaries. I don't know whether they are my beneficiary or not.
This is what has been mentioned. On the basis, you don't know, how do you know? If you don't know, these are the reports as to whether, how do you know alleged? They may have been. Because it doesn't, otherwise it doesn't pose it. Huh? If you say alleged, means you know who are the persons who filed it. On the ground that was issued on 16/11/2024. Now, Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, submits that the impugned order is being assailed on the ground that the very proceedings, right from the show cause notice to the passing of the impugned order, have been passed behind the back of the petitioner. In that regard, the learned counsel further submitted that the so-called notice is based upon certain purported complaints and on the basis of a report, but neither the purported complaints nor the report was furnished to the petitioner, for which the petitioner was not in a proper position to defend his case by submitting the reply. He therefore submits that the impugned order is required to be interfered with. By contra, Ms. B. Bhuiyan, the learned senior counsel appearing on behalf of the petitioner, respondents, submit that the petitioner have indulged in activities which were not only prejudicial to the department but also to the beneficiary, inasmuch as there are complaints wherein the petitioner have been alleged to demand money from the beneficiaries And further, the same having been found to be and the said complaints upon inquiry were found to be true. And as such, the question of interference with the impugned order does not arise. The learned counsel, senior counsel for the petition respondents further submitted that the petitioner was also the petitioner also did not in his reply seek for the complaints or the report, and as such, without the prejudice being shown to the petitioner, shown by the petitioner, the question of raising the plea of principles of the violation of the principles of natural justice does not arise. Anything more?
Yeah.
Anything more? I've heard the learned counsels appearing on behalf of the parties. This court would not like to go into the merits, taking into account that what the learned senior counsel appearing on the would not like to go into the allegations and counter allegations made in the instant proceedings as to whether the petitioner had defrauded the beneficiaries or, for that matter, the as regards the veracity of the complaint on the report on the basis of which the impugned order was passed. Be it as it may, it is seen that the petitioner that there are certain complaints and the said complaint has been also verified on the basis of the report. If those are the materials on which the respondents wants to rely upon, the petitioner ought to have been given an opportunity so that he could defend his actions on the basis of those purported complaints and the report made there against and the report there so made on the basis thereof. This court also had duly taken note of the impugned order, wherein it is also seen that on the basis of the report being submitted, the impugned order was passed. Under such circumstances, it apparently appears that the rights of the petitioner have, in so far as rights of the petitioner to be provided with an reasonable opportunity have been violated. It is, however, seen from a perusal of the affidavit in opposition filed by the respondents, number 5, wherein the complaints, the complaints as well as the report have been duly enclosed. Taking into account that now the petitioner has the complaints as well as the report on the basis of which the show cause notice as well as the as well as the impugned order was issued, the petitioner can now also be permitted to submit a reply, and appropriate directions can be passed upon the concerned respondent authorities to consider the said reply and thereupon take a decision as deemed fit in accordance with law. Next, accordingly, the instant writ petition stands disposed of with the following observations and directions. Number 1, the petitioner herein is given the liberty to file a reply within a period of 30 days from today. To the show cause notice dated 16/11/2024. Full stop. It is observed that if the petitioner fails to file the said reply within the said period, that is, on or before, on or before 12th of December 2025, the impugned order dated 16/1/2025 shall continue to hold the field. Number 2. The respondents herein, more particularly the respondent number 5, is directed to decide the said reply so submitted by the petitioner within 60 days from the date on which the petitioner submits the reply, comma, within the time so permitted herein above, bracket, within the the said decision be taken.
He's not already submitted his reply. His grievance is that the copy of the inquiry has not been punished to him. Already inquiry has been done. Lordship, the copy of the inquiry is with the affidavit annexed with the inquiry, the affidavit in opposition. Will provide him the inquiry report and he'll, Lordship, he may submit the appropriate reply to the
Court has
inquiry
said-
report
court
and
has-
thereafter application.
Court has also said that.
What is the order I am passing?
If I'm not wrong, to the show cause notice. But not to the- He has already submitted his reply against the show cause.
Understood.
Yes.
So therefore, that show cause reply is, I'm giving him an opportunity to submit.
But-
No. Against that inquiry, that report, the
Yes.
inquiry report is here.
Yes. His grievance is the copy of the inquiry.
Madam, you don't listen when I pass the order. So you take the order, do whatever you feel like. You don't understand what I'm speaking. Should I give it the dictation in Yasmin's? Then,
Lordship, no, my lord, no, whatever.
no, the question is, what, you don't, are you not following what is happening? Are you not following what this court is passing an order?
Lordship, if I'm not wrong, Lordship has observed against the show cause notice, he will submit the reply.
Yes.
He has already submitted his reply.
Am I not aware of it? That is his specific contention also. Then. Huh? And such decision be taken within a period of 60 days from the date the petitioner submits the reply. Bracket, within the time already stated, permitted herein above. Full stop. The order so passed herein, however, shall not influence the respondent authorities in deciding the reply to the show cause notice dated 16/11/2024. Full stop. Next, this court further observes that the order dated 16/1/2025, which have been subject matter of the present challenge, shall be subject to outcome of the said decision to be taken pursuant to the reply so submitted, bracket there, within the time so permitted herein above. And if no reply is submitted within the time so stipulated herein above, the order dated 16/1/2025 shall hold the field.
Thing, my lord, till order is passed, the impugned order may kindly be suspended that.
No, absolutely no. I said it will be subject to outcome. Therefore, I've given you 30 days for here. And then in the meantime, I've directed them to comply within 60 days to pass the order. And this order will be subject to the outcome of that proceedings, that order to be passed.
Within this 90 days period, my lord, that.
Yes, but provided you submit within 30 days.
So that may kindly be clear when.
I made it very clear. What else should I say? Why should I say 90 days? It may be 75 days also.
So So hard language officers do not know many times, my lord.
So you are there? Go and explain it to him.
For motion item one.
Yes, what is this?
My lord, non-payment of contractual bill, your lordship. My lord, operating part at page 11, my lord. Para number 7, your lord. Direction is not complied.
Where is PH? Anybody from PH? PH, na?
PHE, my lord.
Whom have you made party?
My lord, chief engineer and number 2, executive engineer Dhuri.
And the Assam Public Health Engineer, why you are not making the secretary?
Secretary. My lord, I think these 2 persons are appropriate respondent authority.
Hmm? And why you are making the executive engineer party?
Executive engineer Dhuri division, your lordship.
Yes, why you are making him a party?
He is the authority to verify the claim of the petitioner, I think.
Understood. But did you provide the certified copy upon him?
My lord, same copy was submitted before that.
Where?
My lord, that is not annexed, your lord.
Then,
But
if you don't enclose that, why should we issue notice upon respondent
this
number 2?
This 13 may be filled, your lord. This 13,
That is what I have seen, page
Well-
13. It is not given to the executive engineer.
but same copy has been submitted. That copy, Xerox copy is not available with the petitioner, your lord.
So we have to assume and presume. Absolutely. We'll get hold of that PHE council. PHE council.
Item 3.
Yes. What is this, Mr. Pathak?
My lord,
Whether the contract has been signed or not?
it has been signed, my lord.
When?
From the railway side, it has been completed on 30th of July, my lord. 30th of July, 2023,
And 90 days thereafter,
my lord. 90 days thereafter, passed in October,
it will be the 30th of July.
my lord. August,
1, 2,
September,
3.
October.
So it has to be by 30th of October.
October. In fact, the council.
And when did you make the request?
My lord, we had made a request when they served us. The first request was made, my lord, when they served us a notice.
When
Without
did you
signing
make
the
the
contract
request?
agreement, they served us a notice under the clause for that explanation as to slow progress of work.
Huh?
As to slow progress of work, they served us a notice, my
Where
lord.
is your request?
My request, my lord, that page 33, lordship,
Eight?
page 33. Page 33, this was
33.
page 33, my lord, part of annexer 5.
This was made when? 22/7,
22/7.
before the contract was entered into.
My lord, because.
And now on the
because-
basis
because-
thereof.
Because before that, my lord, without signing the contract, they served us a notice, my lord, under the contract, saying that you give us explanation as to why there is slow progress of work. As to why there is slow progress of work, my lord, we were served a
And you
notice.
failed to abide by the instruction issued to commence the work to show adequate progress of shifting of so and so. You are therefore given 7 days in accordance with we have to.
On
make
21/7
work
day serve as a
to
notice.
Make
my
good progress, dealing with further actions provided under SWAN. This was given on 21/7
lord. 21/7, my lord. Page
and this
29
contract agreement was entered into thereafter.
thereafter, my lord.
On
We signed on 29th, railway signed on 30th, my lord. Sorry.
now what happened thereafter?
My lord, we have been thereafter repeatedly requesting that your handing over of site and drawings, etc., has been slow. So therefore, you cannot put us on blame. Therefore, the matter has to go.
So why you are not making a request for them to them for sending it to that? Now they have already constituted.
We
At
have-
that point of time, it was not
It
constituted.
was not constituted.
So now
We have been repeatedly, my lord,
Where?
requesting.
where is that representation for sending it to that board?
But there are multiple communications, my lord.
Oh, only
Firstly,
show me
Lordship will see-
one. We don't require so many. One,
Lordship
only
would
one.
look at page 64 again,
Page,
64.
yes, where is that? Immediate appointment of in compliance with so and so. Reference of so and so. Construction amenities of so and so, so and so, so and so. Okay. These are compliant for appointment. I'm not on it. Whether they appoint or not is another thing. You want the reference of the dispute to that board.
My
That is what you are asking.
My lord, the reference can happen only when, my lord, the board is appointed.
Whether they appoint or not, that
My
is
lord.
another thing. But where did you ask this? Because it is they are to appoint it.
We have been
So
asking.
where is your request for that this matter be referred to him? Because for this court to pass an order, you have to request, don't you think so?
My lord. My lord, page 33 was my initial request. You are hereby requested to refer the matter for further DAB. For
That
further
was at a
investigation.
time when there was no contract.
My lord.
Then?
And thereafter, my lord, there are several correspondences, my lord. We have
Only for constitution. So I can only pass an order for constitution, not for reference. That won't help you. Why don't you better make a request to them for referring and then come back to this court?
My lord, in fact, multiple requests are there, my lord. As I,
Where is the request to send it after the contract with after 3 months?
my lord, in all our correspondence, my lord, this reference is there.
I am only asking you where you want. Show me one line that kindly send this dispute to them, to that board, please. That is not there. Who? Who are you? Who is appealing? Get hold of another CGC who can come.
The instruction,
Not
I
you.
think Mr. Gupta had shared with me this morning that the appointment of the DAB is under process by this office.
It's okay. They are in process. Then only the reference will happen.
My lord,
But you have not requested that.
no, our original request stands, because before signing of the agreement, they give us a notice under the
Understood.
agreement
So,
that you please explain.
so therefore, you say that this notice has no value, taking into account that after that you have entered into the agreement on 29/9, 29/7. So after 21/7, they are saying that they are taking steps under 62, but are they not giving up their right when they enter into an agreement after 7 days? 62 is for 7 days notice. So after this, 21/7, exactly after 7 days, they enter into an agreement with you. So therefore, this document has no value as of now.
Thereafter, they give further notice, my lord, on 18/9, Annexer 10,
Page,
page 42. Referring to that earlier notice, now this is, my lord, 48 hours notice.
so now after this, where you have asked for sending it to DBB?
But after that, we have replied, my lord, sir. On 19/9/2025, my lord, Annexer 11, we have replied.
A single letter saying that.
Case 45,
45 read it, where is it?
my lord, that's, sir.
You are
the court-
only replying.
We had already requested you to appoint the DRB for adjudication of the dispute
Wait, wait,
between
wait.
us in
Ah,
making
the
clause.
sir, as per the contractor has requested you to appoint the DRB for adjudication of the dispute between us in respect to Swen. But your good office is silent on the matter for the last 2 months. That sir, in a notice of DM so and so, we requested him for timely intervention for smooth running of the project. Okay, this line is enough. So you have to show me this line only. So they are not yet constituted.
Not yet. They say today now they are under the process, my lord. That seems to be the instructions today,
So we can dispose it of directing them
my lord.
to do so because it is the mandate of the AR to do it within 3 months. And the agreement was entered into so and so. And that immediately shall make it and then thereupon they will refer the dispute.
My lord.
Wait for some time when Mr. Gupta or any
Well,
responsible CGC comes, not his junior.
There is actually go down 15, another, my method is going on there.
Okay, very good.
We'll get back. my lord.
Yes, we'll have it up. Yes, Mr. Azhar.
Release of ST money, my lord. Payment have been made, my lord.
Huh?
Only ST money,
SD money
my lord,
only.
my lord.
Bill also.
Bill already paid, my lord.
Bill
Bill have been paid, my lord.
only SD money.
Yes.
How much?
3,89,000.
3,89,000. Pending since when?
It's work order from 2000, work order, my lord, 2015 work order. Payment have been made to 2024, my lord. After filing contempt petition, my lord.
Huh?
After filing contempt, thereafter payment have been made, my lord.
So at that point of time, you forgot to ask for the SD. Something to the repair. Yes, why haven't you paid the SD money?
Me taking.
1 week?
No.
Because SD, I put interest at 18%. Because SD is the thing which they are entitled. From the date they are
Page
entitled.
29 says not that.
Huh?
Page 29 of the petition says, second paragraph, there is no any liability against the contractor as the work has been cancelled by the higher authority. The SD money may be released as part of it. They will release it.
So this was given date of completion of 2016.
My lord.
And this is given when? This document?
9/6/20.
9/6/2025.
20?
9/6/2025.
25 or 20?
25, my lord.
2025.
25.
Why on earth after 9 years he has given?
No, my lord. Payment was not made, my lord.
You have asked for two, to release SD money deducted from the bill at an early date and to prepare the incomplete final bill so as to pay me the full amount.
My lord.
There are two prayers.
SD money deduct from
Now
Yes,
what do you want? Only SD money,
only SD money,
nothing more than that.
nothing.
So representation dispose of does not arise
Yes, that may be.
because on 9/6/2025, after 2016, you submit a representation. The executive engineer on the very day issues a liability cert. Isn't it?
Right.
So your prayer has been already allowed. So that is not there. only as to whether there is a requirement of release of the SD amount. And how do you say that this 3,89,000 is the SD amount?
If my total bill amounts 48 lakhs, my lord. If 8% deducted from my bill, if 8% deducted, that amount will be, my lord, 3,89,000. Generally, SD money, they will deduct, my lord, 8%.
And without the final bill being prepared, how can your SD money be returned?
My work is complete, my lord.
Was it
Subsequently,
complete?
they have cancelled their.
No,
the
there is
work.
no liability against the contractor as the work has been cancelled by the higher authority.
Yes, my lord.
So if the work was cancelled by the higher authority, then how can there be a date of completion of the work?
Further, they will not continue the work, my lord.
What?
My part, my lord.
You've
I have
heard of something like that, Mr.
My part,
Huh?
I have completed, my lord.
Mr. Azad, every day I take non-payment of dues.
Right.
Therefore, this is to be very strictly scrutinized, more scrutinized than those tender matters. Anyway, we issue notice 1 week. Get your instructions. Now, there's a requirement. You get your instruction whether as regards this document.
Lord.
Because this is very serious.
Lord.
Because nowadays I put the CID into business. Yes. Issue notice making it returnable on 24th of November 2025. Mr. N. Upadhyay accept notice on behalf of the respondent numbers 125. Which
Finance is there.
none appears on behalf of the finance department on call. Who's the copy of. However, there being a finance standing counsel of the finance department, this court permits the petitioner to serve a copy of the writ petition to Mr. Arbo Puraji, the learned standing counsel of the finance department. Extra copies of the writ petition be also served upon Proenzo, who appears for the respond numbers 1 to 5. Mr. A. Azad, Z. Azad, no?
AK Azad, madam.
A.K. Azad, the learned counsel appearing on behalf of the petitioner, submits that in respect to the work pertaining to Pushkazoni FIS bracket page PH Roman 2 under AIBP 2013-14 for the construction of Flux 1 CH.0-650M R/SN/TH.0-250M L/S of Mongoldoy Division bracket 1 bracket Roman 1 Mongoldoy Group Part 1 Group Number 1 Part. The petitioner is entitled to a security deposit of 3,89,084. However, the same have not been paid. In that regard, he have also placed before this court that pursuant to a representation being submitted on 9/6/2025 to the executive engineer, Mongoldoy Dalgaon Sipaza Division, who is the respondent number 5. On the very day, the executive engineer, the respondent number 5, had issued that the petitioner may be released the security deposit. And as such, the petitioner has approached this court. In spite of no release of the security deposit pursuant to the communication dated 9/6/2025. Mr. N. Upadhyay, learned counsel appearing on behalf of the petitioners, respondent number 1 to 5 shall apprise this court as to whether the petitioner is entitled to the security deposit as have been sought for in the instant petition. And if so, when the said payment would be made.
Item 5.
What is this?
My lord, this was pertaining to those uniform. This case was left out, my lord. It was not listed.
This is a new matter.
not new, my lord, it was filed prior to that, but then that day it was not, my lord, defect was not cleared. But then WBC
What?
5532, lordship had already passed the judgment
Ah,
on 4/11.
ah.
So there's no meaning of this petition as of now. The issues otherwise are already covered in that judgment, my lord. So I have instructions to withdraw, my lord.
Yes. What? What should I do? Mr. Hart, Mr. B. Pathak, the learned counsel appearing on behalf of the petitioner and made appears on behalf of the respondent number 1 and 2. It has been submitted at the bar that the issue involved in the instant writ petition have already been settled by this court by the judgment and order dated so and so.
4/11, 4/11,
You
2025.
got a copy?
But I don't, I have a soft copy only.
Everybody has got it. 4/11/2025. In
WPC 5532 of 2025, which is the lead case.
in WPC number. Your matter was 5574, na?
My lord,
Isn't it?
my lord.
You see, I remember.
Good memory with figures.
Taking into account when you approach after 15/9, obvious. And that have been is covered by the judgment of this court in the case of in judgment and order passed by this court dated 4/11/2025 in the case of Rahul Enterprise and others versus the state of Assam and another bracket WPC number 5574/2025. Wherein this court observe that the enclosure to the communication dated 23/2025 shall not act as a bar in the participation of the bidders unless and until there are orders passed for blacklisting by following the procedure prescribed under law, procedure mandated under law. Mr. B. Pathak, the learned counsel appearing on behalf of the petitioner, submit that the petitioner case is squarely covered by the facts mentioned in the case of Rahul Enterprise, Supra, inasmuch as the petitioner herein also could not participate on account of the petitioner's name being reflected in the enclosure to the communication dated 23/2025. This court have also perused the material facts of the present writ petition as well as the judgment passed by this court dated 4/11/2025 and is of the opinion that the direction so passed in the said judgment would apply insofar as the petitioner in the instant case. And more particularly, the conclusion at paragraph 30 therein. For the sake of clarity, this court makes it clear that for the present procurement process of school uniforms, no effective orders can be passed insofar as the petitioners are concerned. Petitioner is concerned. This court further observed that till orders are not passed for debarment oblique blacklisting, the petitioner herein, by following the mandate of law, the respondents herein cannot debar the petitioner to participate in future procurement process subject to fulfilling the other eligible conditions. Next. This court further observes that the findings and observations made herein, however, shall not preclude the respondents as well as the authority concerned to take steps for blacklisting or debarment of the petitioner, if so advised by following the mandate of law. Finished.
Coming item 1.
Oh. You see, there is this order has been passed. Just find out what has happened. As to whether you have complied with it or not, or what is the status, because there was a direction to make payment or to verify and pay. So find out as to whether any verification has been done, and because 3 months have been given. The instant application has been filed alleging willful and deliberate violation of the order dated 28/10/2024, passed in WPC number 2206/2022, whereby this court specifically directed the respondents to verify the claim of the petitioner and release the pending bill amount if so entitled in accordance with law within a period of 3 months from the date of receipt of the certified copy of the order. So it is seen that pursuant thereto, the petitioner herein have issued a communication on 8/11/2024 to the chief engineer, PHE, who is the respondent number 1 herein. The same was also received on the same date as have been stated by the petitioner. However, even beyond the period of 3 months, the petitioner have not received any amount, and it is being alleged that there is a willful and deliberate violation to the order passed by this court dated 28/10/2024 in WPC number so and so. This court requested Mr. R.R. Gogoi, the learned standing counsel of the PHE, who was also the counsel who represented the respondents in the writ proceedings, to make an inquiry as to whether the order dated 28/10/2024 in WPC number 2206/2022 have been complied with or not. Full stop. A copy of the petition, contempt petition, be also furnished to him during the course of the day so that Mr. R.R. Gogoi, the learned standing counsel of the PHE, who is in a position to obtain instructions, full stop, list this matter again on 3rd of December 2025. Full stop. The registry shall indicate the name. We have it on 10th. 1 month means this 1 month if not, you finish it. On 10th of December. In the meantime, indicate the name of Mr. So-and-so in the call list.
Item 6.
May I, Your Lordship? Page 15 is the RTI reply, Lordship. And relevant part liability statement is at page 21.
Which department?
What are
Sorry, it's called. So madam, I'll issue notice only in respect of all amount except 2,71,737. I won't. Rest taken, not for this 2,71,000. Issue notice making it returnable on 9th of February 2026. Mr. Arenda, Mr. Arenda accepts notice on behalf of respondent number 1, 4, 5, 6, and 7. Mr. B. Bukel accepts notice on behalf of the respondent number 3. None appears on behalf of the Revenue Department when the matter is called for. The case of the petitioner herein is extra copies of the writ petition be served upon the learned counsel who represents the respondent numbers 1, 3, 4, 5, 6, and 7. As regards the respondent number 2, the copy of the writ petition be served upon Mr. R. Pujari, who is the standing counsel of the Revenue Department, all within by tomorrow. The case of the petitioner herein is that the petitioner was issued various work orders wherein no payments were made except in respect to one work order wherein certain per payments were made. It is also seen that pursuant to an RTI information sought for on how did you get this RTI information? When did you get it?
Lordship, page 15. On 35, 2025.
The petitioner have also enclosed sought for certain information under the Right to Information Act. And it has been duly mentioned that the petitioner, there's an outstanding amount of rupees 2 lakhs, 2 crores of 14 lakhs 90,786. The respondents are directed to bring on record their stand by filing the affidavit on or before 30th of January 2025 as to whether the petitioner is entitled to the said amount, and if so, when the said amount would be paid. Name of the GSM be reflected in the contents.
Item 7.
Revenue name also not shown? Not shown? Name of GSM and revenue be shown in the contents. Yes, ONGC R Sharma, what is there? You are there.
The same tender, Your Lordship. The same tender.
Same tender, it's
Yes.
not ending.
No.
Yes. What has happened this
Your
time?
Lordship, because these are tender for the hiring of scrapping winches, 12 numbers of units in Assam. And one of the mandatory criteria was that they have to either possess their own vehicle and the winch, or to give an MOU that they are going to purchase. That clause Your Lordship has seen. And now, in that regard, it is a mandatory condition. And if they are not qualified, if they cannot fulfill that condition, then they ought to have been technically disqualified. However, and the documents, Your Lordship will remember, the documents that have been uploaded by the bidders were not visible to all the contesting bidders. So now we have come to know after after opening of the financial bid as well as the contract has been entered with L1, that the MOU that has been submitted by the L1 has not even been signed by the L1, the party there. So it's not a valid document itself. If your lordship turn to page 148, that on that basis, his bid ought to have been rejected in the technical stage itself.
148. What is it?
First-
MOU.
Yes. This memorandum of understanding sale agreement is made on the 13th August. The lordship says only the quick edge, the party is going to supply the winch. He has signed. NK Sharma, the second party, the bidder, has not signed anywhere, though it's notarized. $150 also. None of the page has been signed.
Who got this contract?
He got this contract.
Who?
This NK Sharma, he turned out to be L1.
And where is the requirement of that particular document?
The lordship, page 79. '79 is the scope of work. 80 is the technical qualification. Read with page 87 and 88.
70?
79 is the scope of work.
No, I'm not on scope of work. That is document is.
That those document, your lordship, yes. That your lordship will find at 87 and 88. 88 is the relevant.
Mobilization contract unit of new vehicle, new windshield. So there are category 1 and category 2.
Two, they
Category 1 are those which are owned,
own,
and category are offered scrapping units are yet to be acquired.
yes.
Bidders should submit a MOU agreement with the manufacturer vendor or its authorized agent to supply new winches as per technical and commercial bid, and the winches will be available for deployment at the end of 5 days. Bidders should submit a copy of the MOU agreement with the manufacturer to be you apply to it.
So lordship, this
So
is
this is, so he applied in category 2.
two, and this has to be submitted along with the techno-commercial bid itself.
So this, he had submitted the MOU, but not an MOU signed by and between the vendor and the respondent number 5.
Right. So
That's
it
your
is
case.
not a valid agreement. He has not given his consent. And your lordship, in the other one, as per the vehicle, this was the winch. The lordship will find at 145. Here he has signed the 2 pages, but the main last page he has not signed.
145.
This is regarding the vehicle 145. Gar Motors, NK Sharma. Here he has signed 145 and 46 he has signed. But 147 he has not signed, the last page.
Somebody else has signed?
Yes, he is the authorized representative. That,
Or and on behalf of?
yes, that's fine.
Yes.
But for 147, if a lordship sees 147, that he has not signed. Only the Garg Motor, the manufacturer has signed.
Where?
47.
Now, has he provided the winches?
He has part of a separate company.
Because 30 days is gone.
Gone.
Has he provided the winches? No. What do you mean?
But your lordship, he ought not to have been technically qualified itself. And if the illegality is allowed to be perpetuated,
Hello? Yes, what is it?
On the merits, I'll have to nationally, not only yesterday, but there are some issues I think need to be brought to your lordships on this. The contract was awarded on 15th of September. This same contract was challenged, award of the contract was challenged by this same petitioner. And your lordship passed the judgment on merit. This fact has been entirely solved. Can it be allowed that we will keep on finding new grounds every time and come back on
Because
challenging?
last 6 months, I am only doing no other work except this. These 12 winches is the issue which is going on before this court. I passed, I think, 4 judgments.
And this is a judgment on merits challenging the same award of the contract. This fact is suppressed, firstly. And secondly, Your Honor, this is clearly hit by constructive res judicata. And now what it, another aspect, Martin. This is absolute. If your lordship sees paragraph 3, this same very award is challenged by same Rajiv Hazarika. Response number 5 is the same. And it is considered on merit and dismissed. Now this fact, he does not even, he chooses not to disclose. Comes before this honorable court now on a new ground. And the other interesting thing your lordship will find,
So this contract is for 5 years, na?
5.
The next 5 years, how many cases are you going to file, Mr. Hazarika? How many cases you are going to file?
this would be the last, your lordship, because
Why that?
this document, we have got it on 111, because they have still not opened the portal, so we are not being able to see what documents. So what,
Again, you are going to get something more in the portal.
if they open it at
You-
once,
How did you get it, that MSC thing?
your lordship, if they are going to cancel it, then they have to,
How did you get the MSC? That response number 5 did not participate as an MSC.
that we didn't get, see, this time, that we got it from we got in possession from
How?
somewhere.
How? So every time you are going to get one, and you are going to keep on coming.
This we have made,
We give you a limitation of 3 years. So all 3 years you keep on filing. And we keep all these matters in a stack. So after 3 years, we'll dispose of together. What do you say? All your grievances, because it will keep on coming. I dismiss this one, he'll come up with another. Though order 2, rule 2 would not apply in a writ proceeding. But explanation,
we have got this document
explanation.
after the contract has been entered. We got this document now. This document.
You may say tomorrow also again another.
But the lordship, if they had,
Isn't it your relief out there to disclose in the earlier petition for providing copies of all the documents? Wasn't it your relief sought for? I didn't pass. So if I don't pass, then explanation 4 to section 11 duly applies. If it applies, and that provision of constructive res judicata duly applies to it, the Supreme Court also says I need not say. So, anyway, I should not on the first day dismiss your petition because I think this matter should be kept pending. Because me dismissing out here, this is the 4th. This will be the 5th. If I keep on dismissing, he comes again. So let him amend, keep on amending when he gets involved. That is better. What do you say? No stay. Let you think up after accumulation, then it becomes so, then we
There's another aspect also. If your lordship will kindly come to page 137. This respondent number 5 is L1. He is not even the L2. So even assuming your lordship sets it aside, it will be the L2 who will get the benefit. Now, L2 is not even made a party. And this is an aspect he does not even again disclose. So what is his locus to even put this to question?
Anyways, let us see because Mr. Chaudhary, another thing, what I mean, that is on a technical aspect as regards the constructive res litigator. If he has come up with the aspect pertaining to his knowledge which has come later on in view of certain more disclosures, because that was one of the reliefs which was also sought for at that time. But if these are not memorandum, there is no agreement which is, he has shown to document. To be an agreement, there has to be signature of both or meeting of minds of both. And then we are concerned with parity. Whether there is a parity being given to amongst all. And there are cases also wherein another Mr. Pukan's case, all of you are together. No?
In fact, that matter is also listed today.
It is a cartel amongst the lawyers also. Huh? So that case, he could not participate. He had only one winch and he challenged it on the bail. If this is a particular thing for which he could not participate, he said, what happened initially, if I remember, there were 10, which was, the earlier tenderer was removed, 2 remained, and then made it 12. So they have gone. And Mr. Pukan's client's objection was that I have only one winch. And therefore, you are asking that all 12 winches are to be given. So therefore, don't do it. Then I dismiss his petition. So then you come.
No, that petition is pending. It is listed.
No.
That is pending.
Then I did not pass a stay.
Stay.
No. With the same logic, your lordship issued notice.
And there the
To avoid multiplicity burden.
These winches have become witches. Anyways, I
Your
think
lordship just keep the maintainability open. There are other questions on maintainability.
the maintenance definitely is open. Should notice because he has already provided. Now, therefore, third party rights have also come in. So staying now would be stopping the operation. So stay cannot happen. Issue notice making it returnable on and get it by 8. Serve upon respond number 5 by 8th of December 2025.
Can it be any other date, madam?
Why?
That particular week, I have to. I'll be
Oh,
aware.
Mr. Chaudhary, are you a standing counsel? You can't be a senior counsel. Senior counsel, no commitment. He has difficulty.
I'll leave it.
Yes, 8th of December 2025. Mr. Ivo Roy accepts notice on behalf of the respondent numbers 1, 2, 3, 4. And extra copies of the petition be furnished to him during the course of the day. As regards the respondent number 5, the petitioner is given shall take steps by tomorrow by speed post. In addition to that, liberty given to the petitioner to serve the respondent number 5 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next. This is the second round of litigation wherein the petitioner had challenged the issuance of the grant of contract in favor of the respondent number 5 pertaining to
page 35.
Page
35. Hiring of service
pertaining to
for 12 number.
hiring of services for 12 number scrapping winch units for Assam except for 5 years. In the earlier round of litigation, the petitioner, that is earlier round of litigation being WPC number 5768/2025, the petitioner assailed the grant of the contract in favor of the respondent number 5 on the ground that the respondent number 5 did not participate as an MSc enterprise, as an MSc unit. Be that as it may, the said challenge was rejected by a detailed judgment and order dated 26/9/2025. Mr. Arsha Motherland Counsel, appearing on behalf of the petitioner, submits that till date the entire portal details have not been disclosed, and the petitioner now has come to learn that where is that clause?
Page 88,
Have come to learn that
special terms
there is a complete violation of clause 3A of the special terms and conditions of the contract. Inasmuch as the respondent number 5, though applied as a category 2 bidder, but he did not furnish the MOU/agreement with the manufacturer as is conceivable under law. Referring to the MOU dated 13/8/2025 in respect to purchase of
scrapping winch, page 149.
12 numbers of scrapping winches. The learned, which is Annex 7 to the writ petition, the learned counsel appearing on behalf of the petitioners submitted that this very document would show that only the manufacturer have put its signature and there is not a single signature of the respondent number 5. He therefore submitted that under no circumstances this MOU could have been taken into consideration by the respondent authorities. Further referring to Annexure 8 Collie, the learned counsel submitted that this MOU refers to
This is for the scrapping winch. The previous one is for the truck,
this is for
the scrapping winch.
pertains to 12 numbers of new scrapping winches, wherein also there is no signature of the respondent number 5. He therefore submits that these MOUs could not have been taken into consideration by the respondent authorities while considering the technical bid of the respondent number 5. Inasmuch as without those MOU/agreement, the respondent number 5 could not have participated as a category 2 bidder. Mr. I. Chaudhary, the learned senior counsel, appearing on behalf of the respondent ONGC, na? ONGC, submits that on merits as to whether these MOUs, the MOUs referred to by the learned counsel for the petitioner are there or not, he has to obtain instructions. Be that as it may, the petitioner cannot be permitted to approach this court as per his whims. He submitted that the petitioner had earlier approached this court, wherein the petitioner raised an issue as regards the technical qualification of the respondent number 5, and the said writ petition was dismissed. No appeal thereagainst have been filed. Under such circumstances, when on merits, the decision of the respondent ONGC authorities have been upheld by this court, to grant the contract to the respondent number 5, the petitioner cannot now again be permitted to keep on raising issues as regards this grant of contract to the respondent number 5 in a piecemeal manner. In that regard, he submitted that the principles of constructive adjudicator duly applies to writ proceedings as per the settled principles of law. And the instant writ petition is hit by the principles of constructive adjudicator. So this court, during the course of the hearing, inquired as to whether the respondent number 5 in the meantime have provided the scrapping winches as well as the scrapping units.
Purchase orders have been furnished to the police, and they are.
And it has been submitted that the purchase orders have already been submitted to the ONGC. Respondent ONGC. Taking into account the above, though the learned counsel appearing on behalf of the petitioner has urged for certain interim directions, this court is not inclined to pass an interim directions today without first inquiry, without first permitting the respondent ONGC to place before this court their stand as regards the MOUs which have been submitted by the respondent number 5 for their technical qualification. In addition to that, the respondent number 5 can also bring on record their stand in that regard. The maintainability of the writ petition, this court, taking into account ground of maintainability have been taken, by the respondent ONGC, this court keeps the issuance of notice in the instant proceedings shall not affect the affect the right of the respondents to raise the question of maintainability. This court directs the respondents to bring on record their stand on or before 3rd of December 2025. The respondent ONGC to bring on record their stand on or before 3rd of December 2025. On the next day, this court would further consider on the basis of the stand so brought in. On the next day, this court shall again consider as to whether there is a requirement of passing interim directions.
Objection. Connected matter, item 56, we have filed our affidavit.
They have filed the affidavit on Monday. We require time, but
That is Pukun's matter.
He also is there.
You are there. I told you the cartelization of the councils against scrapping units.
That matter, my lord. If he wants to file a reply, it can be tagged along with the other one.
Mr. Asham, the counsel appearing on behalf of the petitioner submits that the affidavit in opposition has been filed by the respondent ONGC, and petitioner would like to file a reply. So, taking into account above, list this matter along with this petition on number 2, on 8th of December 2025. The reply be filed in the meantime on or before 3rd of December.
oblige.
Apologize, Lordship, my item number 6, the Lordship has notes about Lordship.
Which one?
Item number 6, Lordship has
Revenue.
passed the order, Your Lordship, there. Our name was not reflected in the cost list. Also,
Okay,
it should
so
be
and so
popular
appears for revenue.
towards Your Lordship. That's why the matter got missed.
Okay, you appear for revenue.
The name may be reflected in the cost list.
I've already mentioned that.
Keep the-
Mr. Gupta,
My lord.
you are in the process.
My lord, they have.
So once you form it, then you refer it.
Yes. Yes. my lord.
Where's the clause?
Lord would come to phase 171.
Hmm?
Page 171, my lord. Sixty-three point two point one.
So these are disputes which are not settled by the engineer.
My lord.
Engineer means the
Engineer means, my lord, the supervisor, my lord, that whom we had, my lord, initially represented, my lord.
engineer has been defined somewhere. Engineer means the divisional engineer
Divisional engineer.
or the executive
My
engineer.
lord. Basic.
Do you come under 116, the dispute as regards 11B, 11E, 116? Is the dispute not settled by them or by anybody else?
My lord. Then the DAV. Then the DAV, my lord.
So the dispute is with this engineer.
My
What is the dispute? Where is the dispute?
My lord, firstly, we had formulated, my lord,
DEN means divisional.
engineer, my lord.
I have heard Mr. B. Pathak, the learned counsel, appearing on behalf of the petitioner, Mr. H. Gupta, the learned CGC, who appears on behalf of the railway administration for the railways. The dispute in the instant CD pertains to non-referring of the same to the dispute adjudication board as is set out in clause 63.2 of the, what is that?
Standard general conditions of contract.
Standard general conditions of the contract, which is a part of the bidding document, which is a part of the general of part two. Part two, na?
Part one.
Of part two of the standard general conditions of contract, GCC, April 2022. From the materials on record, it is seen that pursuant to a notice inviting tender, a letter of acceptance was issued on 25/11/2024. For construction of passenger amenities building, one number distributed EI cabin, 3 numbers EI LOC huts, senior CDO office complex, 80 meters into 8 meters, bracket new parcel here. Itu apna annexure 2, page 24 এইখিনি দিয়া, what is the word? Reference. Huh? On (21/7/2025), a notice was 7 days notice was issued in terms with clause 62 of the general conditions of the contract, stipulating therein that if there is a failure to commence the work oblique to make good progress, the contract would be terminated and the balance work would be completed without the participation of the petitioner. The petitioner replied to the same. It is very important to take note of that on 29/7/2025, after the issuance of the notice dated 21/7/2025, the contract agreement was entered into by and between the petitioner and the railways. In that regard, the learned counsel, appearing on behalf of the petitioner, had produced the contract agreement, which is kept on record and marked with the letter X. It is the case of the petitioner that the petitioner have sought for referral of the said dispute pursuant thereto on
Eighteen nine 25.
18/9/2025. Another notice was issued by the ADRM Guwahati NF Railway, which is a 48 hours notice in terms with section 62 of the standard general conditions of the contract. The petitioner replied to the said notice on 19/9/2025 and again sought for referral of such dispute to the Dispute Adjudication Board. It is at this stage relevant to take note of clause 63.2 of the standard condition part 2 of the standard general conditions of the contract, which stipulates the Dispute Adjudication Board. In terms with clause 63.2.1, any dispute, if not settled with the engineer, shall be referred to the Dispute Adjudication Board. It has been submitted that the dispute in the instant case falls within is a dispute between the petitioner and not settled by the engineer as defined in clause 1 bracket 1 bracket E of part 2 of the standard general conditions of the contract. It is also mandated in clause 63.2.1 that a DAB would be formed within 90 days of signing of the contract agreement. This court inquired with Mr. H. Gupta as to whether the DAB the Dispute Adjudication Board have been constituted. It is being submitted upon instructions that the Dispute Adjudication Board is in the process of being constituted. Taking into account that the dispute in question falls within the ambit of a dispute which can be adjudicated by the Dispute Adjudication Board, this court therefore disposes of the instant petition with the direction upon the concerned respondent authorities to constitute the Dispute Adjudication Board forthwith, taking into account that the 90 days period have already lapsed from 29/7/2025, and thereupon the dispute be referred to the Dispute Adjudication Board for their decision in terms with the standard general conditions of contract with above the instant petition stands.
Point 12, we observe that the obligation of the railway and the contractor shall not be altered.
I think we have to continue with the work.
Otherwise,
63.
2.12, page 173.
It is, before parting with the record, this court further finds it pertinent to observe that clause 63.2.12 further mandate that the obligation of the railways as well as the contractor shall not be altered by reason of issue being or under reference to the DAB, Dispute Adjudication Board. So, under such circumstances, the obligations of the petitioner as well as the railway in terms with the contract shall continue irrespective of such reference being made to the Dispute Adjudication Board.
Not only one thing, my lord. 90 days elapsed on 30/10, my lord, not 29/7.
Huh?
90 days had elapsed on 30/10, not 29/7.
37.
Agreement.
No,
90 days
both of
thereafter.
you,
has
he
been-
signed on 29/7 and you signed on
37.
37. That seems appears to be not meeting of mind.
Of late.
Yes, what is this?
Lordship, non-permanent of Lordship, Bill's Lordship. Lordship.
When?
Repetition, petitioner approached earlier Lordship. That was Lordship disposed on,
Where is the direction? Earlier?
direction was Lordship to the respondent number 1 to pass a region order Lordship. Thereafter, they have not passed.
Where is the
Otherwise-
direction? Page,
Page 84 Lordship, start from page 84 Lordship.
we have recording of the concern that the claim of the petitioner be relegated to the commissioner to examine the matter and pass appropriate orders of the claim of the petitioner. And the petitioners are permitted to produce a certified copy of the copy of the petition and any other document which the petitioner may have within 4 weeks from today. On receipt of the same, the state authority shall have within period of 3 months thereafter.
Lordship, they have already admitted Lordship my Bill's Lordship at page 91 Lordship in 2019. 25/7/2019 Lordship. And the last, the bill amounting rupees 8,45,751. Yes.
Then
Then thereafter, Lordship, I submitted the representation. Thereafter, Lordship, in 2023, they said that scarcity of, due to the scarcity of the fund, they have not released the fund, Lordship, that bills, Lordship. And the last communication made by the Lordship on 4/10/2024, asking for fresh proposal for release of the fund, Lordship. The works conducted Lordship in the year 1999, start from 14 June of
what is
1999.
this CAPOL?
Capol is the Lordship society. Capol is the society, and the Capol has Lordship imparted training upon the 427 numbers of group trainers, Lordship. For the training regarding Lordship poultry, fruits, vegetable processing, piggery farming, handloom weaving with jute, etc. in the district of Kasar, Lordship.
Yes, Panchayat, why are you waiting, sitting on it?
My lord, the office order, the work has been done in the year 1999, 25 years back, man. Lordship, may I kindly see the.
No, no,
order also?
whatever may be,
Yes,
pursuant to that, a representation was submitted, whatever may be. There was a disposal by the repetition of the repetition in 2015. Directing, 19, directing you to look into the representation. They looked into the representation and found that rupees 8,45,000 the petitioner is entitled. Pursuant thereto, there has been various communication by this CAPO to you, and you have not paid the
My
bill.
lord, Lordship, I can see page 86, the earlier order, my lord. The submission of detailed.
Ah.
Page 86, where the third page. The learned training council for the PNR department has submitted that the matter is about 20 years old and the state and the stand of the resolution number 5 is that
the correctness of the claim made in the requisition could not be verified due to non-availability of the office record. He further submits that DWCRA program had been discontinued since a long time, and at present there is no specific fund allotted to meet up the expenditure of such an old training program. So at that time, the stand of the department was that, my lord, no record was available and no fund was also available. Maybe that is why, my lord, the result of the thing. I'll take instruction.
Next paragraph.
Yes, ma'am. Then affidavit one affidavit was filed from the district level, my lord. In that, my lord, they're saying that some admitted, and my lordship, I can see the
Read-
certificate
read.
issued by the district level. They have annexed the certificate, no letterhead, nothing, my lord. So therefore, my lord, I'll take instruction.
Which one?
In page, they have annexed, my lord, numbers of certificates, starts from page 27.
No, kindly come to page 91.
Yes.
Now, this is being done by the DRDA.
Yes.
Pursuant to the direction passed by this. Pursuant to the direction passed by the court, this DRDA looked into it and this is the amount they have found. Then were found to be justified. Whether this total amount comes to 8 lakhs so and so, I don't know. But anyway, it seems so.
I know.
Now, thereupon, here it says the total bill amount on receipt of completion issued by the so and so, which have not yet been paid.
May I show one thing, my lord?
Yes.
Page 91.
Ah.
The project director also say that paragraph 4, that as per the affidavit opposition submitted by the P
Earlier PD.
earlier, so those records are not available. Maybe, my lord, because I'm submitting only from the record. Lordship, it may some time.
Lordship, thereafter, Lordship, the chief executive officer has clarified to the Commissioner Lordship at page 95.
90?
At page 95, apart from a bill amount to be 6,500, they have admitted 8,39,251, Lordship. Page 95, the last paragraph, Lordship.
And this is the problem now. The problem, however, is that now this court cannot go resile from that because there is already an adjudication being made. You already have taken the 20 years plea. That was even rejected by the next paragraph.
Yes, yes.
So therefore, if you didn't file an appeal there again, this court can't help it now.
Lordship,
So
kindly-
therefore, on the pursuant to the direction passed, they have made an adjudication and found out there's some amount payable to the petitioner. Now, after that, if you have not assailed that it could not have been paid and nothing, can you raise any dispute in that regard at the later stage now?
My lord, lordship, may issue notice. May
Oh,
place
yes.
the correct instruction.
Issue notice making it returnable. When? They pay for everybody
My lord, no, but finance department and
remaining. One,
I
issue
for one-
notice making it returnable on 3rd of December 2025. Mr. S. Dutta, the Learned Standing Council, PNRD accepts notice on behalf of the respondent number 1,
1, 3,
3,
4, 5,
4,
6,
5, 6, 7.
7, my lord, my lord.
Now there is also Kachar DAD.
My lord, 7, my lord, district
District
commissioner.
Commissioner is there, but it is again connected with DRD.
Actually, DRDA was abolished in the year 2018 itself.
That I know. Then
At present, there is no DRDA.
6. Because he did D and 8.
8 I can agree. But there is no post called PD at this thing. Officially no.
You accept notice for 7 and 8. 7 and 8. Because it comes within your ambit. Because they can't say anything of it. 7 and 8. And Mr. So appears on behalf of the respondent number 2. Mr. S. Dutta, the Learned Standing Council of the PNRD, at the outset submits that though he accepts notice on behalf of the respondent number 7, taking into account that he has been shown as the chairman of the DRDA, as well as respondent number 8, who have been arrayed as the project director, DRDA. But the DRDA, but the District Rural Development Agency, bracket DRDA, stood abolished in the year 2015, 2017, sometime in the year 2017. Extra copies to Italy. This is the second round of litigation. In the first round of litigation, this court, by an order dated 10/4/2019 in WPC number 1109/2015, directed the Commissioner PNRD to examine the matter and pass appropriate orders on the claim of the petitioner number 1, that is the petitioner here number 1, that is the petitioner number 1 herein. Within 3 months from the date the petitioner submits the certified copy of the said order along with the writ petition and the annexures enclosed thereto. The petitioner thereupon submitted the certified copy of the order dated 10/4/2019 along with the writ petition as well and the annexures. Pursuant thereto, upon being directed by the Office Commissioner PNRD Assam to the respondent number 9, and respondent number 8 by the communication dated 9/7/2019, the project director, DRDA, had given a finding on the representation so submitted by the petitioner or on the approach so made by the petitioner pursuant to the order passed by this court, that the petitioner was entitled to certain amounts as has been stated in paragraph number 4 of the communication dated 25/7/2019, and the said amount was also not paid. It is seen that pursuant thereto, on 13th of July 2023, the Commissioner PNRD issued a communication to the Chief Executive Engineer, Jila Parishad Kachar, seeking a justification report in respect to the long pending liability for the amount of rupees 845,751. The Chief Executive Officer, Kachar Jila Parishad Silchar, thereupon on 24/8/2023, issued a communication thereby justifying that the petitioner herein would be entitled to rupees 839,251 for the time period from 14/6/1999 to 7/8/1999. However, in spite of that, the respondent authorities have not made any payment, for which the petitioner has approached this court for the second time, seeking appropriate redirection and order. Mr. S. Dotto, the learned standing counsel of the PNRD department, shall apprise this court on the next date as to why the said amount have not yet been paid to the petitioner, in spite of the decision as well as the justification that the petitioner is entitled to an amount of rupees 8,39,251. So issue notice kete also. On the next,
If possible, 4 weeks. maybe. If possible, 4 weeks.
it's 4 weeks only.
3 weeks.
Today, 1 week, 2 weeks, 3 weeks. Okay, 10. 10 Mr.
Black.
Hello.
Item 9.
What is the,
Lordship, matter relates to non-issuance of pharmacy license, my lord.
Huh?
Pharmacy license, Lordship.
why no pharmacy has been given by you?
Relevant documents are already submitted before the authority, but till date not issuing, my lord.
When did you apply?
Lordship, page 35, it is computer generated receipt.
Page
But page 35, my annexure 7. It is 6/11/2024, Lordship.
where? What is the date?
Date, yes, sir.
Date of application when?
Yes. That is the top of the left, Lordship, that is under binding.
What?
Top of the left, Lordship.
So should I tear up the petition for you and find out
But
where
we-
the date is?
In representation we mentioned, Lordship.
Where is the representation?
36, Lordship, page 36.
11/6/2024.
Yes, ma'am.
Petition notice making it returnable on 28/11/2025. Mr. Coenso accepts notice on behalf of the respondent numbers 1, 2, 3, 4. Pharmacy Council also you appear.
Yes, yes, sir.
1, 2, 3, 4. Assam Pharmacy Council also.
Yes, sir.
1, 2, 3. Extra copies of the writ petition be furnished during the course of the day. The petitioner herein who have what is their degree?
Diploma in pharmacy, my lord.
Who has a diploma in pharmacy had applied for a pharmacy license on 11/6/2024.
Sorry, Lordship, 6/11/2024.
What?
6/11/2024, my lord. 6/11/20.
Here you have written 11/6.
No, no, page 36, Lordship.
Page 37.
Lordship, that is, first one is month, middle one is date. As per their, my lord, computer generation, Lordship, as per computer generation.
Here you have written 11/6.
Yeah,
I will go by this, not by the other one. Other one says 6/11.
yeah.
Why the type copy is different from this?
My lord, oh, sorry, my lord. As I take instruction, my lord, it is 11 is the month, my lord. 6 is the day.
No, it is on 11/6.
My lord.
2024.
That is the American.
No, this is apparent on 11/6/2024. By application number APC/F/2024/9426. Also, the grievance of the petitioner that even after a passage of almost 1 year, the petitioner have not been issued the license. And on account of the non-consideration of the said application, the petitioner has approached this court. Delay in consideration and on account of the delay of the non-consideration of the application of the petitioner has approached this court. The respondents herein are directed to bring directed to apprise this court by way of instructions as to why the petitioner's application have not yet been considered. Has been apprised this court as to whether the petitioner's application has been considered? And if not, why?
In this matter, Mr. S. Bodhakur will appear. Mr. S. Bodhakur will appear. Can I pray for a password for the time?
Why?
Mr. S. Bodhakur will appear in this matter. He's leading us in this matter.
What are you challenging?
Lordship, the entry taxes in respect of the trucks and other vehicles have been increased, Lordship.
Where is that?
Lordship, page 22 is the first notification of increasing the taxes.
What is your ground?
Lordship, prior to increasing these taxes, Lordship, there has to be an approval of the governor. And if your Lordship kindly looks at page 23, they say that the enhanced rate of entry on vehicles and animals shall be applicable with immediate effect for temporary arrangement and subject to the approval from His Excellency, the Governor of Assam. So they admit that the approval is not there, but they have brought it into effect with immediacy.
In the second one?
Second one is they slightly decrease the enhanced rate in respect of our trucks, Lordship.
Huh?
We are an association of truck owners, Lordship. So we have
In the
certain.
interest of smooth movement of the getting of subject to So you say that this is without these notifications have been issued, without the concurrence of the governor.
Lord.
That's your stand.
Yes, sir.
We have enacted the next law, as per paragraph 8 of the 6th schedule to the Constitution of India. Paragraph 8(1)(b). Paragraph 8(3)(c) of the 6th schedule. The district council for an autonomous district shall have the power to levy and collect all or any of the following taxes which such district, that is to say, taxes on the entry of sea matter, taxes on the entry of goods into a market for sale therein, and food on passengers and goods carried for sale.
Where? This one?
Paragraph, my lord, what's it?
Where?
Paragraph 8, my lord. Power to assess and collect then revenue and to impose taxes.
Paragraph
8. 6.
For autonomous shall have the power to levy and collect all or any of the following within the district, that is to say,
C.
taxes on selling, parental taxes on animals, on the entry of goods.
C.
Now 6(4), like 8(4) says you have a regulation and that has been approved by the governor. So that line which is being mentioned out there has no relevance. This kindly come to page.
That is wrongly put back.
That was not necessary.
That is only the publication part. Paragraph 11 relates to publication of the
Regulation. No,
That is
it is
wrong.
only the regulation. A regional or district council, as the case may be, we may make regulation to provide for levy collection of any taxes specified in Iman, and all
Entry of
and
this paragraph.
every regulation shall be submitted for fit to Iman and until
Posted to the
extended
governor
shall
and
have no
accepted
effect.
by him shall have no
So the
effect.
question is whether a revision
My lord.
would require a
Approval or not, my lord.
of the government.
And we have made the regulation in 1983, the date that has been prescribed, my lord, that has been increased, my lord. My lord, in, my lord, paragraph, my lord, 6 also, we have the executive power, my lord, of the state to extend it, my lord. In exercise of the executive power, my lord, we have the power to enhance it temporarily, my lord, until the governor, we got the assent of the governor, my lord. After, my lord, regulation, we have the assent of the governor, my lord, for increasing the rate, my lord. At the rate has been fixed at that time at the rupees 10, my lord. After, my lord, 42 years, my lord, the rate has been increased, my lord. The rate fixed earlier as per the regulation of 1983, my lord. Now in 2024, we have increased the rate, my lord. At least, my lord, whether in the meantime, it is on notification of 2023, Lordship, from this time, we will take the instruction whether we have received the assent of the governor or not regarding the, if it is required, my lord, regarding the, my
But
lord,
does it say that it requires unless the regulations,
regulation.
you have the regulation here, na? Where is the
Is
regulation?
268, my lord.
Huh?
Is 268 of the book. Karyalam District Miscellaneous Taxes and Codes Regulation 1980.
Two 268.
Well, it's 6, my lord. This is the tax on animals and vehicles. Regulation.
You are on Karbi Anglong District Miscellaneous Taxes and Tolls.
Codes Regulation 1980.
Ah.
My lord, codes, my lord, Regulation 3. And tax on animals and vehicles.
Every
Regulation
person resident within the list shall pay ₹10 per head per annum as toll unless otherwise accepted by the executive of direct. Where's the tax on
No, it's,
entry?
Regulation 6, Lord.
5 and 6, my lord.
5 is given. The year
My
may
lord,
from
market
time to
taxes and
time
taxes on
prescribe
entry of goods.
rules, bylaws,
market.
regulations for the collection of taxes and taxes on entry of year two. The market for sale therein at the rate as mentioned in Schedule A. This is done under 5.
My lord,
6, Lord.
vehicles, my lord. 6, vehicles is also there. Goods and vehicles. See, my lord.
Where is the tax for entry?
6C, Lordship.
Animals passing through district of Karbi Anglong to any place outside shall be liable to a tax on the entry at the rate as. This is only passing through.
Passing through, my lord, this is the B, my lord, when the animals, my lord, elephants are passing through the Karbi-Anglong, we are, my lord, they have to pay tax. And C, my lord, it is the vehicle.
Or in absence of any person in charge of entering the Iman shall be liable to pay tax at the following end, provided the central government or the state government of Iran owned by them shall not be liable to pay any such tax. So here, this is the tax.
Tax, my lord. And
This
we
is,
have
this is
now
not as per
increased it.
schedule.
My lord,
This is not as per the schedule.
not cheated, my lord.
Now, the
Now we have-
power is given for modifying
My lord.
power, market tax and tax on entry of goods into market. This is only for market five,
Market, my lord.
but this is on entry within the district of
This is,
Karbi
yeah,
Anglong.
vehicle. Entry of vehicles in the, my lord, under the territorial jurisdiction of Karbi Anglong.
So this is under Karbi Anglong.
My lord,
So 5 and 6 are different.
different, my lord.
Now, here they are alleging, challenging, this notification being done where?
Page 22, Lordship.
2023, my lord. 2023, my lord.
Then have been made 200.
But subsequently it is modified in respect of it is 50 miles.
Hmm?
In 2024, they have annexed it as it is modified to 50 rupees per ton.
So this is being done by whom? Karbi Anglong Autonomous
Karbi
Council.
Anglong Autonomous.
And the power to sue. But where is the power to increase? Or is it that the power to levy includes power to increase?
With the provision 10 is the appellate provision. If any person is agreed, they can prefer an appeal to the executive committee by law. And 11 is the to make the bylaws by law.
You made bylaws?
My lord, bylaws also require to prior approval of the governor of Assam by. My lord,
No, but one thing. Whether the power to levy includes the power to increase. That is, there's a difference out there.
But
more particularly when Regulation 5 says,
my lord,
from time to time prescribe bylaws and rules for collection of
Right.
so and so and for sale at the rate mentioned in so and so. May from time to time
time to time,
means they keep on changing.
it can.
But
be changed.
here it is not being given in grade 6.
My lord, the trucks entry, my lord, goods could be entry to the, my lord, autonomous council through, my lord, car or vehicle, my lord.
Huh.
Goods can only be entry, not by, my lord, in any way, in the manner. It should be through, my lord, vehicle. So when the vehicles enter with the goods, my lord, we have the power to impose the.
No, there's no denial.
My lord.
But whether the power to increase, power to levy
But
includes the power to
The word is
increase.
there from time to time, my lord, prescribed,
That is not here. It is time to time is given in 5.
my lord.
Where is the time to time in 6?
My lord, 6, there is no, nothing, no provision.
So
in the six.
therefore, it cannot do. Therefore, the question involved here is whether the power to levy includes the power to increase.
My lord,
In fact,
here, my lord, it is the entry of the vehicle, my lord, with goods. If it is with goods is there to sell in the market, my lord, paragraph 5 is, clause, regulation 5 is applicable. If the goods with the, if the truck is, empty truck is entering, then the only, paragraph, my lord, 6C is applicable. my
but
lord.
why they are exercising powers under section 11?
11 is not there, my lord, it is wrongly mentioned. 11 is the publication of the notification.
Ah,
11 only is required to be published, my lord. So in all our notification, my lord, that was published, that has been mentioned. So that is wrongly
because
mentioned. my lord.
one thing very important out here is entry tax gate shall be enhanced to so and so.
Right.
So entering Karbi Anglong, taxing tax on animals.
My
So
lord.
this is being done. Because what happens, it also affects the power, because no, in terms with the other provisions, the entry tax have been already, all have been repealed in view of the GST coming in.
But here, my lord, that point is there, my lord. Under the 6 schedule, we have the specific power on that. When the paragraph 12 of the 6 schedule says that if the autonomous council make the rules, my lord, central can state that is not applicable, which is for the contravention to that part. Paragraph 12.
No,
So, my
there's no
lord, we
quarrel
have the
with that.
power.
There's no quarrel with that. But
So, in
whether in your case,
Right.
whether GST is applicable in Karbi Anglong,
Right.
because you cannot say no.
No, yeah, no, I cannot say, my lord.
Because
GST is
GST
applicable across
otherwise
my lord.
subsume all taxes including entry tax.
My lord, that aspect is the long aspect of the matter, my lord. It is a, my lord. That regarding when the GST is applicable, whether we can impose tax other than the GST.
Because you are,
And that
otherwise,
encourage.
otherwise your state, the district will have a far-reaching consequences.
My lord. Yes, my lord. If the, my lord, power is not there also, my lord, the autonomous council is required to, state autonomy is also required to be maintained, my lord. And for that purpose, my lord, collection of the taxes is required, full is required to be collected. So the provisions of the 63 is, my lord.
So there are two questions.
My lord.
The second
My lord,
question, I
yes,
think
my lord, I
we
am
should
understanding,
not
my
go
lord,
much.
My lord.
But the
I have
first,
already, my lord, my advice has already been given in respect of paragraph 6C also, my lord. What is the manner they have put in the 1983, my lord, that is required to be amended, my lord. I
Amended.
have already given that.
and because the power to levy may not include the payer to revise, because tomorrow if the executive chairman council said we make it 2,000,
My lord, if
which
I-
has been, it appears, yes, for a long time,
My lord.
but from 100, then it has become
My lord,
200.
that is the question, my lord. My lord, when the matter came to me, my lord, for advice, my lord, after the going through the governor and like that, my lord. So that process is going on, my lord. I have also given my opinion to the my lord. So regarding that, lordship rightly pointed out all those points, and that queries also came back, my lord. And I have also answered it, my lord. So lordship may fix it on Monday.
No, not Monday, we'll issue notice, give you
My lord,
time.
my lord.
I mean, there's no question of stay.
My lord.
Yeah, because
Yeah,
here.
it is the process is going on, my lord. I have also given, my lord, whatever the lordship thinks that regarding.
Because
the power of-
whenever it is a question of recovery,
Fine.
a realization, the question of stay does not arise, because the moment the stay, tomorrow you may not be able to recover.
Yeah.
But Lordship,
That question which lordship puts, my lord, that question comes for the governor. Regarding that particular question.
Yeah. I'll put it in my,
My lord.
I'll put it as his argument.
Lordship, because otherwise, this is basically an amendment of the regulation, which requires the assent of the governor also.
Why?
As per para 8 of the 6th schedule, Lordship.
What did you say?
Lordship, if I may read, a regional council or district council, as the case may be, may make regulations to provide for levy and collection of any of the taxes specified in subpara 2 and 3 of this paragraph. And every such regulation shall be submitted forthwith to the governor, and until assented to by him, shall have no effect.
Understood. So the regulations is required to be submitted.
Yes, regulations are there, and as per the regulation, they have
So
prescribed.
the regulations is already there.
Yes.
But the question is whether the regulation which permits them to tax, because you see, there's another thing. You have to also apply the General Clauses Act, wherein it says that the power to do a particular thing also includes its incidental powers. But again, the question applies as to whether the power includes or not. That will be looked into. But for that, is it required to amend, whether they have the power to amend the schedule? Or is it required to be sent to the governor? There is nothing mentioned in these regulations. So therefore, there are two aspects of the matter. First, whether the power to levy includes the power to revise or amend the act without the approval of the governor. And the second is, now can they do so in view of the GST? You see, what has happened with the GST coming in, all entry tax have been subsumed. And there's no quarrel that in Karbi Anglong people are paying GST. It is not immune from GST. So therefore, if GST is being collected and which subsumes all taxes, whether this can be done, whether the existence of this thing, like just for example, the VAT, all these other taxes, Assam Entry Tax Act, all these things have been already subsumed by virtue of that constitutional amendment. Anyway, you should notice.
The basis of your lordship judgment matter, that query comes to me. my lord.
Which one?
Regarding taxation, lordship, the
because
application of rate, my lord, whether it can be exorbitant one. Lordship has a passed judgment of it. Only on that basis, my lord, that question comes to me, my lord, to my advice for my. Referring to that particular.
Which one? For that one?
My lord, taxation, my lord, regarding tax, my lord, exhaustion rate, government, financing, passed judgment.
On LT. No, this is on the agricultural produce. But then also I did not allow the refund on account of Muffat lands. Okay, issue notice making it returnable on 3rd of December. Mr. Deputy, the Learned Standing Council of the Karbi Anglong Autonomous Council accepts notice on behalf of all the respondents. Extra copies of the petition be furnished to him during the course of the day. The petitioner herein, which is an association of truck owners of Dhansiri area in Golaghat, have filed the instant writ petition assailing the various notifications issued dated 30/11/2023, 8/5/2024, 24/7/2024. And further, have also assailed the regulation 6, further in the alternative, have assailed regulation 6C of the Karbi Anglong district bracket miscellaneous taxes and tolls regulations 1983 as unconstitutional. Mr. S. Day, the Learned Counsel appearing on behalf of the petitioner submits that taking into account that the plea pertaining to alternative plea alternative plea so taken, the petitioner for the present would not insist. Otherwise, I lose my jurisdiction. Yeah, we will submit that the imposition so made by the impugned notifications dated 30/11/2023, 8/5/2024, and 24/7/2024 is in fact violation of paragraph 6C of paragraph 8, in violation of paragraph 8 of the 6th schedule to the Constitution. Inasmuch as without the concurrence or without the assent of the governor, these impugned notifications cannot be put into effect. This could also heard Mr. K. Trippier, the Learned Standing Council of the Karbi Anglong Autonomous Council, whereby who submitted that he would obtain instructions in that regard. Be that as it may, upon hearing the learned counsels appearing and also perusing upon perusal of paragraph 8 of the 6th schedule and the Karbi Anglong District Miscellaneous Taxes and Toll bracket close regulation 1983, it appears that the question arises. It appears that two fundamental questions arises. The first question pertains to as to whether the power to levy which has been given in terms of paragraph 8C of the 6th schedule, read with regulation 6C of the regulations of 1983 would permit the Executive Council to revise or amend the schedule to the regulation without the assent of the governor. Number 2. The second question which arises is as to whether after the
PSP point has not argued my lord.
Lordship, actually, if I may kindly submit, Lordship, that goods and vehicles.
one question arises. The affidavit be filed on or before. On or before 28th of, 1st of December 2025. Did it take that? The way important for.
There is no
Much
claim,
of
right? But if the claiming is that, then we will see what are there. Otherwise, it will not happen.
Yes, it's not, let us not destroy Karbi Anglon's power.
My lord, there was a tender dated 17/2/2023, my lord, which was settled in favor of respondent number 6. The settlement order, my lord, is at page 41. But prior to the settlement order, my lord, your lordship will kindly come to page 33. It's a representation dated 26/5/2025, my lord, where we preferred it before the government, stating that the composition of the members of the respondent number 6 society does not comprise of 100% actual fishermen. The comparative statement, my lord, is at page 44. Page 44 is the comparative statement, my lord, where respondent number 6 was the highest bidder, and the petitioner is bidder number 5 in terms of sequence. 44 is the comparative statement. Now, my statement in paragraph 11 and 26 of the writ petition, page 44, man. Serial number 1 is the respondent number 6, who have been settled with the fishery for 7 years for a sum of 92,09,904.
What is the petitioner? Where is the petitioner in the?
The petitioner, my lord,
statement?
yes, my lord. The petitioner's name features at serial number 6 at page 46. I am the 5th highest bidder. I'm the 5th highest bidder.
So you quoted 661.
Yes, my lord. Because,
300 per year
Yes.
totaling to so and so.
yes, there is a reason for that, my lord, but that reason, I'll avert that reason in a little while, my lord. Now, what has happened is your lordship comes to paragraph number 11 of the writ petition. Paragraph
So
11.
wait, where is the private respondent?
Private respondent, my lord,
No, here.
number 1, serial number 1. 92 lakhs, man. 92 lakhs.
Yeah.
Your lordship sees that? 92 lakhs. Now, what has happened, my lord? In terms of sequence, bidder number 2, 3, and 4, they have taken their call deposit. So now they're out of the fray. Now, if the tender is to be cancelled and re-allotted, my lord, it will come to me. But that is a separate submission, my lord. Now, my submission is primarily based on the fact that the composition of the respondent number 6 society does not comprise of 100% actual fishermen, which is a requirement under Rule 12 of the Assam Fishery Rules. Now, we had preferred our first representation at page 33. There was no response to that, and the order of settlement was issued in favor of respondent number 6. Now, in the meantime, what had happened is the second highest bidder had also approached this honorable court. The order is at page 48. The order is at page 48, and the operative portion, my lord, is at page 50, my lord. 50 and 51. 50 and 51. Paragraph number 6. On considering the submissions made by the councils for the parties, this court is of the view that the issue is an issue to be decided on facts, as the competent authority to decide the said issue is the respondent number 5, which is the ARCS, my lord, who had issued the certificate dated so and so. This court directs the respondent number 5 to re-verify whether these serial numbers, my lord, these members of the respondent 6 society are actual 100% fishermen or not. Now, whether that exercise has been undertaken or not, my lord, the petitioners are not aware of that. Now, my lord, in that regard, we have certain verifying, substantiating facts. Your lordship will kindly come to page 52. Page 52. This is the latest representation which was preferred by the petitioners, stating that, again, the membership of the community, the 100% fishermen, they're not 100% fishermen. To substantiate that, your lordship will see page 58. We have given RTI documents pertaining to 2 different members. Page 58.
Where's the?
Page 58. Page 58. In what post Arun Hira works in SBI? Arun Hira is working as a FOS at Morigaon. He has been working as FOS since 28/11/2022.
Now, Arun Hira, my lord, his name features at serial number 52 at page 58.
What
Serial
do you
number
want?
52.
What do you want?
My lord, as of now, your lordship will issue notices. But in the meantime, my lord, there should also be a direction to the respondent number 5, the ARCS, to conduct an inquiry into the composition of the fishermen society, my lord, respondent number 6. And if they understand, they find out that all of the members are not fishermen, the membership list, my lord, is at page 38. We have 2 documents to show that one of the members is still inside the bar for the past 2 years, and one of them is an employee of the SBI. Now, on exactly the same set of grounds, my lord, this honorable court in an earlier writ petition, my lord, had decided on the issue.
There are 19 members,
They have 90 members, my lord.
30 members.
On page 40, page 30,
They have 30 members.
my lord,
How many members?
80 members, my lord.
But
80
now
members.
most of that, some are.
Some are. Even if one do not fulfill that criteria, that the allotment is liable to be cancelled, my lord. In fact, there is a judgment of that on this honorable court where in an earlier occasion, my lord, there were 2 instances or 2 individuals who had grocery shops. In fact, it pertains to the same the fishery and the same respondent number 6. But that can be dealt with at the later stage for hearing, my lord. As of now, your lordship will issue notices and direct the ARCS to, in the meantime, conduct an inquiry into the composition. It's a 7-year lease period, my lord. Not even 1 year has lapsed. So we have enough time for us to enjoy it, subject to the report of the inquiry.
What about the second L2? He has given up
2, 3, and 4, they have taken back the call deposit, my lord, the security deposit.
after filing the writ petition.
No, not after filing, but they are separate, different entities, my lord. In the meantime, after the settlement was allotted to respondent number 6, they've taken back the call deposit.
No, understood, but they didn't one L2 file the writ petition.
The second highest bidder had filed a writ petition, which your lordship had just perused at 48. Now, whether they're agitating the matter before the authorities or not, we are not aware of that.
No, but they have taken the call deposit back.
They have taken the call deposit. That's my submission, my lord. That's my on oath. I've made that submission that they've taken the call deposit back. Now, if the tender is to be cancelled from respondent number 6, it is my submission on oath, my lord, that I am the second most responsive bidder. There's another one who is below me, but that his case cannot be considered, my lord. Again, subject to verification of my membership also. That is my case, my lord.
And this tender was issued when?
My lord, 17 to 2025. 17 to 2025 by respondent number 3.
And who is paying for the fishery department? You. Now you have made a rule, if I'm not wrong, a rule by which the increase has to be 10% increase.
Yes.
Have you also taken note of that in this? Although he has not argued that.
I have not argued that.
Obviously, because he also fails
Yes.
in that regard.
That is
You-
laid down,
you
my lord.
also fail
Yes,
in that.
yes, my lord.
But whether that rule has been taken note of, because there is an amendment to the rule, I think rule 43 or something. What is the rule? I forgot.
My lord, that rule has been taken care of by the authorities. It is at page 41, my lord. Page 41. The second last paragraph.
Rule 48.
Yes, ma'am.
7 years despite specific instructions to follow the process of putting 10% on the first year's bid on a cumulative basis for the next 6 years.
Yes, ma'am.
Under Rule 48
Eight.
as intimated by 24.
Yes, ma'am.
So it doesn't appear from the comparative chart that you have taken note of that. Obviously, he's not raising that issue.
Yeah.
But the fishery department have been doing this. By cancelling many tenders, as I could see, on the basis thereof. And this court has also upheld it. So therefore, why the state or why the authorities are not complying with Rule 48? Take that issue notice, making it returnable on. Then you may have to go for a fresh tender. He would not get. He also doesn't satisfy 40.
But at least I'll satisfy Rule 12.
Rule 12 is okay. If
yes.
48 goes, then forget about anything.
In
You are
fact,
not
my lord,
going
there's
to get it.
another ground which I ought to raise subject to your lordship's final observation. If your lordship kindly come to page 23.
No, one ground is enough for you. I've added the second. So with that, enough for the report. issue notice making it returnable on when? 1st of December 2025. Ms. SCTA accepts notice on behalf of the respondent number 1, 2. Mr. MCT accepts notice on behalf of the respondent number 3, who appears for 4 and 5. 4 and 5 appears here. So extra copies of the petition be served upon them during the course of the day. As regards the respondent number 6, steps be taken by way of speed book by tomorrow. So in addition to that, the petitioner is also directed to effect service by way of dusting, routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that in pursuance to a notice inviting tender for settlement of the 165 of the 166, 166, 167 of the 158 Purana Punal oblique Sola oblique Borongo oblique Tukraj group fishery. The petitioner, along with various other bidders, including the respondent number 6, have participated in the said bid. Admittedly, the petitioner is L6, L5, having quoted an amount of rupees 661,300 per year, totaling to rupees 46,929,100. However, the contract in question have been awarded to, settlement in question have been awarded to the respondent number 6, who have quoted 92,09,914, that is 13,15,702 for 7 years, for each year, for 7 years. It is the specific case of the petitioner that all the members of the respondent number 6 society are not 100% actual fishermen. And as such, it is in violation of Rule 12 of the Assam Fishery Rules, 1953. Mr. M. Sharma, the learned counsel appearing on behalf of the petitioner, further submitted that the L2, in respect to the said the L2 bidder had in fact challenged the settlement so made in favor of the respondent number 6 by filing a writ petition being WPC number 3094/2025, wherein there was a specific directions on the part of the respondent authority, on the specific directions by the learned coordinate bench of this court, thereby directing the respondent number 5, that is the Eastern Register of Cooperative Society, to make inquiry as to whether all the members of the society in question are 100% fishermen. The learned counsel submits that the respondent number 5 appears to have not carried out any such exercise. Who is the respondent number 5 here?
Respondent number 5 is the ARCS Morikawa man.
Okay, here. The respondent number 5 herein, however, have not carried out any such exercise. So the learned counsel further submitted that on that basis itself, you are for L2 also.
My lord?
You appeared for L2 also.
My lord, there was a separate writ petition, my lord.
Maybe.
My
All are cartel.
No, absolutely not. My lord.
Cartel.
My lord, we are not aware of.
Why is the same counsel for L2 and L3?
L2 has, in fact, has withdrawn their money.
Understood.
My lord.
So now L6 has come in.
They have come in on
Isn't it the case of cartel?
My lord,
When they are engaging the same set of counsel.
my lord, my senior has some proficiency in fishery matters, my lord. That's why
What?
proficiency in fishery matters, my lord. That's why they've come.
Including you.
My lord, I'm junior of my senior.
So, why did you appear for L2?
L2 has actually excluded itself from the fray.
Maybe,
Taken back
but
that
now
consent.
therefore you want to, once L2 goes, they are now to settle it at 66.
My lord,
Now they are to settle it at 66.
66, my lord.
L1 has quoted 92.
92, my lord.
You,
In fact, that-
you
that
have
is-
quoted 66.
Now, there's a reason why. There's a
No,
reason why.
no.
My lord,
Yes.
we could not. have-
And the
my-
reason I'm telling you
Yes,
why.
sir.
You have quoted 46,
There's a,
half of it.
my lord, your lordship will kindly come to page 23, my lord.
We do one thing, we exercise 48 and cancel the entire.
My lord, page
No,
23, my lord, page
I
23.
think this is the
Lordship-
best way. No,
Lordship, for a moment.
I will take it as a submission and cancel the entire. Because 48 mandates it is.
No, but my lord,
Then
that
your
is-
cartelization
my
will
lord,
be
that is
finished.
one of the grounds. My lord, if I was a part of the cartel, my lord, I would have quoted an exorbitant amount.
You are the cartel.
No, my lord.
You are the link amongst the in the cartel.
My lord, it's just the councils happen to be the same, my lord. There is no connection.
Absolutely.
My lord, the subject matter was different.
You
as
should
much
not
as
have
the
accepted it.
But the documents were not connected to
No.
that petition, my lord.
L2 is that who asked for, didn't do it because L2 now has to pay more. So L2, L3, L4 goes out. Now L5 comes in and therefore he
And-
wants it at
No,
46.
my lord, if L2,
This is a public waste of revenue.
my lord, if
Public would
L-
lose.
if L2 had gotten it, my lord, we would have had no case. But again, my lord,
We will consider, take it, you make a submission also that you are willing to pay 92.
I cannot.
No,
as per
no,
tender, I
make that
cannot, my lord.
submission.
My lord,
Otherwise,
lordship will come to
public
page
exchequer is
23 for a
losing.
page 23, my lord.
No,
I'm
no,
not-
no, I am not looking into all this.
Page
thing.
23, the revenue has
no,
been
no.
reassessed by the government at
impose-
2 lakhs.
No, this is cartelization.
My lord,
That is why your senior has not appeared.
my lord, he's in
The
bereavement, my
senior's
lord.
name appears in glowingly out there.
Bereavement, my lord.
He knew that this is going to be the situation before
My
the
lord, my
storm.
senior is in bereavement, my lord.
No, that is
My
why.
lord, that sum could not have been quoted by respondent number 6 in the first place. That is one of the submission I would have made, man. He could not have, my lord.
He's
because-
taking up, otherwise they will cancel it. They know what to do. If he have quoted 92, he'll get paid 92. Why on earth should they? This is a case of cartelization
My lord,
between you and him.
92 is a misrepresentation of the
No,
text of
no,
the
this
text, my lord.
we dismiss it
Because
right
it was
away.
reassessed, my lord.
Division bench will help you. They are merciful judges, not like me.
My lord will kindly consider and reject my case at
I
page
think this should be
23.
dismissed right away.
My
On
lord,
the
page
basis the council are saying,
My lord, page 23, for a
Madam,
moment, my lord.
make that submission. Make that submission. Cartel. Thereby losing the public revenue.
My lord, page 23, your lordship.
No.
Observe and reject my case.
I am rejecting right away on the basis of cartel.
My lord, my lord, absolutely, my lord, there is no intention behind to defraud
There is
this court.
absolutely intention behind.
There is no. my lord,
Why, after getting this order on 6/5/2025, that is why my question was,
Yes.
why L2 gave up? After filing a writ petition, getting an order, he gives up and takes away his call deposit. L3 gives up and takes away. L4 gives up and now L5 stakes a claim.
my lord,
Who is going to lose at the end of the day?
that revenue is unrealistic, my lord. That is my
Whether it is unrealistic or not, that is not my concern. If they don't get it, madam, if you don't get it, you know how to realize. So,
My lord, that entire revenue
Not bona fide.
protection, my lord, that revenue protection by the bidders was not realistic.
anyway, like, okay. Whether submitted. On the basis of the order passed by this court on 4/6/2025 in WPC number 3094 of the 2025, that there was a specific direction passed by this court upon the respondent number 5, who is also the respondent number 5 herein, to inquire as regards the member of the respondents number 6 society as to whether they are 100% actual fishermen. The learned counsel for the petitioner further submits that no such steps was taken, and the respondent number 6 now continue to enjoy the settlement order. He therefore submits that this is a case wherein interference is required, inasmuch as there is a violation to clause 12, Rule 12 of the Assam Fishery Rules 1953. Per contra, the Ms. S. Sutir, the learned counsel appearing on behalf of the Fishery Department, submits that the filing of the instant writ petition does not seem to be bona fide, taking into account that L2 had filed the earlier set of earlier litigation being WPC number 3094/2025. After getting an order passed therein on 4/6/2025, thereby directing the respondent number 5, wherein directions were issued to the respondent number 5, wherein directions were issued to the respondent number 5 to make verification as regards the authenticity of the 100% fisherman's certificate issued to the respondent number 6. The said L2, who was the petitioner in WPC number 3094/2025, have conveniently withdrawn the call deposit. The Learned Counsel for the Fishery Department further submits that not only that, the L3 as well as the L4 also, as per the submission made by as stated in the writ petition, have also withdrawn the call deposit. Now, the respondent number, the petitioner, who is the L5, quoting half the amount of that which have been quoted by the respondent number 6, stakes a claim. He further submits that even the counsels who appeared on behalf of the L2 as well as the L6 are one, as well as the petitioner, are one and the same. The Learned Counsel further submits that this is a case of cartelization, and as such, the same should not be permitted. Taking into account the submissions, it is the opinion of this court that such aspects be brought on record by filing an affidavit on behalf of the respondents, so that the same can be adjudicated upon. This court further takes note of. This court further, during the course of the hearing, inquired with the Learned Standing Counsel of the Fishery Department as to whether Rule 48, as amended, of the Assam Fishery Rules 2012 to 1953, have been adhered to, in as much as it is the mandate of the law that that all bidders quote, all the bidder, that the bidding should be 10%, there should be an increase of 10% on the first year's bid value on cumulative basis for the next 6 years. Ms. So-and-so submits that your affidavit will be filed on or before the next date. In respect to the queries, in respect to the submissions so made, as well as the queries so raised by this court. Ms. So-and-so, appearing on behalf of the respondent number 5, is also directed to apprise this court as to whether there has been a compliance to the order dated 4/6/2025 in WPC number 3094/2025. The maintainability of the writ petition is kept open.
Item 12.
May I
What
please,
is
Lordship?
it? Non-payment.
Yes, my lord.
Hello. Next date, 5/6, no, 6/2. 6/2, to affidavit by 30.
All right.
My lord, in this case, I want. Lordship, can you allow 1 week time to file an additional affidavit to bring on record some documents, which I received by the petitioner yesterday. 1 week time is maybe granted to file an additional affidavit.
Why?
Because the petitioner filed some RTI, which I received yesterday. They compared with certain other documents.
Mr. N.J. Gogoi, appearing on behalf of the petitioner, submits that the petitioner may be permitted 1 week time for filing an additional affidavit in view of certain further relevations under the Right to Information Act 2000, 5. Taking into account the above, list this matter on 21st of November 2025.
15.
What is this?
May it please your lordship.
Ah,
Lordship, the present writ petition is being filed, lordship, in relation to the work tendered and accepted by the NF Railway under tender notice dated 28/2024, which lordship will find at page 44, annexure 3.
setting aside and quashing the impugned termination notice.
Yes,
You have been
lordship.
terminated.
They have issued a termination notice dated 4/9/2025, stating that lordship that we have not supplied the quantity which was supposed to be awarded to the petitioner, lordship. Lordship, we have explained our delay, why we cannot supply that quantity, lordship.
Ah.
Now, lordship, may kindly turn to page 44. This is the tender agreement, tender document, lordship. And letter of acceptance was issued on 2011/2024, which lordship will find at page 136.
What is the value of your contract?
Lordship, the value of the contract is 12 crores 38 lakhs 54,842.
How much?
12 crores, lordship.
Then why you are not going for arbitration?
Lordship, here the arbitration clause is there, but lordship, the notice which was issued, lordship, under clause 62, that clause is not arbitrable, lordship. As per the
That
standard,
clause
is not arbitrable, lordship.
Why?
As per standard general condition of contract rules, lordship, may kindly turn to page clause, lordship, 63. 63, page 119. Though we have made us application before the arbitration for demanding the initiating proceeding of the arbitration, lordship, but lordship, as per clause 63, lordship may kindly turn to page 119. Here, 119 is lordship.
Why all disputes and differences of any kind whatsoever arising out of in connection with each so and so, whether before or after the determinate shall be referred to the contractor by to the chief engineer of the month, and notice dispute provided no notice thereafter shall be served later than 30 days after the date of issue.
Now, lordship, page 120, lordship.
Ah.
Matters finally determined by the railway.
Yes.
All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and the GM shall, within 120 days after receipt of the contractor's representation, make and notify decisions on all matters referred to by the contractor in writing, provided that matters for which provision has been made in clause 7J 8 so and so. Our notice was, lordship, issued under clause 62(1).
So these are clauses, all these
Stated as
clauses will
accept
come under the
matters.
accepted matters.
Yes, and matters not arbitrable.
Then
And decision of the railway authority.
come within the ambit of these clauses.
Yes, lordship, clause 62. Because the termination notice was issued by invoking clause 62, lordship.
62 or 62?
62, lordship.
Here it is 62.
Here 62(1).
Where is 62(1)? Right of way after rescission. This is done under 62(1) or 62(2)?
62(1), lordship.
Termination owing to the default of the contract.
Yes,
If the contractor.
170. Here there is no clause 62.
So where is your termination?
Termination notice, lordship, will find at page 140, annexure 5.
So what is the ground on which it has been terminated?
Lordship, we have made a reply, Lordship. Lordship may kindly turn to page 176.
Sufficient length of circulating area has been developed for so and so. It is evident that you have given sufficient opportunity to rectify the situation. 48 notice was given to you under this letter of sufficient act. So and so the So this is done under 62(2), not 62(1).
Lordship, here 62(2) is Lordship basically.
In the event of any of the several measures of forces referred to under so and so being adopted. So these are the things which have been adopted. 48 hours notice, 7 days notice, all these things have been done.
Yes.
Then also you could not do it. So
Lordship,
therefore, they have taken the recourse in the contract rescinded, the full performance guarantee, the security deposit, defaulting contractor shall be issued no completion, the balance work will be done anywhere without the risk and cost of the failed demand. The failure shall be debarred from participating in so and so. So this is it. This is done under 62. This
Lordship,
will definitely come under it.
our main grievance is, Lordship, the delay was primarily caused due to suspension.
That delay I am not going to. That is between you, arbitrator, and them.
Lordship,
How will I know about your delay? How can I adjudicate? What do you say?
All which has been referred, my lord, at page 119. So this is the contract which is below 50 crores. Conciliation of disputes clause 63, page 119, that would be applicable.
Then if it fails, then arbitration.
Yes, yes. My lord,
There will be an arbitration which is permissible.
Page 119.
See down below.
If
If the parties reach an agreement on the settlement, they shall draw up a say and so, and this is the conciliation. The parties shall intimate, the conciliation shall be in terms with so and so, all disputes on so and so. The conciliator is 53.
Clause 5, parties shall not initiate during the conciliation proceeding any arbitral or judicial proceeding in respect of a dispute that is subject matter of conciliation. So this is clause 63, conciliation of disputes should be applicable. So they have to effectively also moreover, they have already invoked the bank guarantee in the performance guarantee.
Lordship, my contention is, Lordship, the delay was caused due to suspension and cancellation of the mining areas, Lordship. That is in the Parku Pahar range, Lordship, which is adjacent to the Kaziranga National Park.
No,
And
you
in
will
terms of
come under
Honorable Supreme-
64.
60
In the event of any dispute between the hereto as regards constant operation or respective rights of the parties, there are dispute or differences or any account on withholding of any certificate to which there may be claimed to so and so fails to make a decision, then in such a way, but except accepted matters referred to in section 60, clause 63(1). 63(1) is
63(1) is.
pertaining to conciliation.
Yes,
After 120 days, but within 180 days of presenting of the final claim on the dispute shall demand in writing, the demand of area, so it will come under 64. Arbitration.
Lordship, but our grievance is, Lordship, that in terms of the Honorable Supreme Court order, Lordship, that is 3/6/2022, Lordship. Here, Lordship, the Honorable Supreme Court had directed to close all the mining areas, Lordship. In the Parku Pahar range, this is the only area, Lordship, from where the petitioner procured the materials, Lordship. And those mining areas were, Lordship, closed due to this order, Lordship. And because of that, Lordship, we could not supply the materials, Lordship. We have already mentioned these things, Lordship, in our representation letter dated 8/9/2025, Lordship. We have mentioned that we cannot supply these materials due to the Honorable Supreme Court order.
What is your interim prayer?
Lordship, staying the operation of the impugned judgment and setting aside of the impugned.
Please read it, page 31.
Our interim prayer is, Lordship, stay the operation and implementation of the impugned termination notice dated 4/5/9/2025 issued by the respondent number 2, that is Senior Divisional Engineer Lamding Division NF Railway pending conclusion of the arbitration process. Lordship, this is
So
not,
you want this court to be a section 9 court?
Lordship, since we have.
Does this court look like a section 9 court? We don't have an original jurisdiction. It is that particular district judge who has it. So you have an arbitration proceedings, that means.
Even though, Lordship, there is a
So if
judgment
you
of the
want
Honorable.
some interim relief under section 10(9) to approach there.
Lordship, I have a decision of the Honorable Supreme Court, Lordship, where the Honorable High Court can entertain the writ petition even if there is an alternative remedy, Lordship.
There's no quarrel with that, but your prayer is that you have an arbitration.
There is the apprehension that they are going to encash our bank guarantee.
So therefore, section 9 is the appropriate court. Why should this court exercise this? You have a court, it is a fair court, then are you saying that the district judge is not capable? This is not going to go to any of the officers. Why you are not approaching the district court?
Lordship, under Article 226 of the Constitution of India, Lordship, the Honorable High Court has the power to adjudicate this matter, Lordship. Lordship has the.
You on your own hand say that there is an arbitration.
Yes, Lordship.
So when that matter is already being taken into account by the arbitration, why this court should interfere?
Limited prayer is until the disposal of the arbitration proceeding, Lordship. No coercive action may be taken.
Madam, you have powers under section 9 to approach the district court, or section 17, which is equally powerful. You can apply before the arbitrator. Why you not going there?
Because, Lordship, here the reason stated by the petitioner is genuine, Lordship. So, Lordship, because of the urgency of the case, we approach this honorable court.
Is it
under
so
Article
urgent that you can approach the high court, but you can't approach the district court?
If it's correct, but Lordship, with my limited knowledge, Lordship, it is my humble prayer.
With my
Lordship.
limited knowledge, I will only issue a notice and see what they have to say. And then after getting their knowledge from them, whatever it is, then I will consider as to whether an interim order is to be passed. Better,
Apply.
isn't it?
Lordship, because our contention.
We'll have it next year. We'll fix it next year. In the meantime, whatever you want to take over entire money and all and finish it off. So there's no stay.
Lordship, that will be very harsh upon the. Lordship.
Absolutely. When the lawyer out there the lawyer of the petitioner doesn't understand the basics of the law.
Just compare.
Absolutely, madam, you have to go before that. I'm not going to entertain this type of petition here. Okay, let me dismiss it right away. Huh?
I have also the judgment, Lordship, here.
Many.
2025.
Many. Alternative, maintain a public law limited is 1 year.
Lordship, for.
Hey, what is it? Rare. Heard Miss M. Sharma, the learned counsel, appearing on behalf of the petitioner. And Mr. So-and-so, the learned counsel learned CGC, who appears on behalf of the respondent number 1 and 2. The present petition has been filed challenging the termination notice dated 4/5.09/2025, as well as seeking a direction upon the respondents to refund the earnest money deposit, the security deposit, as well as the bank guarantee. Further to that, the petitioner have also sought for a relief that the respondents be also directed to permit the petitioner to resume the balance work after the withdrawal of the mining ban in accordance with the binding directions of the Supreme Court. It is also seen that in the instant writ petition, the petitioner have sought for the following interim reliefs, the same being relevant, are reproduced herein under page 31 and 32. 1, 2, 3, 4. Without going much into the merits, it is seen where that termination letter,
Lordship, termination letter is at page 140. 140.
that the respondent authorities now, without entering it is relevant to observe that by the impugned termination notice being being dated 4/5/09/2025. It was mentioned that the letter of acceptance was issued on 2012/2024 with a completion period of 12 months. And the performance was found to be wholly inadequate. It is also mentioned that the petitioner had supplied only 1535 TUM of ballast since the last loading done on 28/2025. Resulting in issuance of 7 days notice and 48 hours notice on 9/7/2025 and 24/7/2025. Under such circumstances, in exercise of powers under clause 62, the contract with the petitioner was rescinded and the balance work under the contract would be carried out independently without the participation of the petitioner. Further to that, the security deposit and the performance would be further to that, the security deposit would be forfeited and the performance guarantee would be encashed.
Lordship, Lordship, I would like to add one point here,
It
Lordship.
is the case of the petitioner that the delay, that the petitioner was not in a position to make the supply in view of certain orders being passed by the Supreme Court. And as such, the said termination was not in accordance with law. At this stage, this court finds it very pertinent to take note of that the power to terminate, power to rescind the contract is provided in section clause 62, bracket 2 of the general standard. What is the name of here?
Lordship, the general standard
The general standard terms and conditions of the contract,
conditions of contract part 2.
part 2. And it appears that the same was done in pursuance to the powers exercised under 62(2) of the said act. Of the said contract agreement. This court further finds it relevant to take note of clause 64, wherein, which is an arbitration clause, question therefore arises as to whether this court should at all exercise the jurisdiction. That too when the petitioner had himself approached for the arbitration proceedings, for initiation of arbitration proceedings. And more particularly when the prayer, the interim relief so sought for, is specific that these interim directions were the directions were to be passed during the pendency of the arbitration proceedings. It is the opinion of this court that Section 9 of the Arbitration, Section 9 and Section 17 of the Arbitration and Conciliation Act 1996 provides adequate safeguards to the petitioner to approach if the petitioner wants any interim directions pending the arbitration proceedings. Considering the above, this court therefore is not inclined to entertain the instant writ petition for which the writ petition stands dismissed. The dismissal of the instant writ petition, however, shall not prejudice the petitioner to approach the court in terms with section court within the meaning of Section 2E of the Arbitration and Conciliation Act 1996, seeking interim directions in terms with Section 9 of the said Act, or the arbitral tribunal in terms with Section 17 of the Act.
I would like to add one point, Lordship.
No
Here,
point.
in the termination notice, they have stated that we have supplied only 1535 cubic meter stone. But Lordship, we have supplied already 12,000.
Madam, all these things, I therefore said I am not going to decide anything. I am only referred to the arbitration notice, termination notice, what they say. This is not my finding. Therefore, all these things, and the dismissal also shall not operate there.
Supplementary item 50.
My lords, I'm appearing virtually in item 50. I hope I'm audible to my lords.
Oh, where's the record? How many site verification certificate? 2. Site verification, photograph same.
But before taking that into account, the senior office where the tender was open, they verified it from the executive increase as to why the similar identical photos were there and who was, and so out of the 2 persons who were the successful. That was thereafter they have taken that. That's all available in that.
There are 2 aspects. This is PWD.
Yes.
PWD clause 7.
Here,
Clause 7.
Year 6.
Okay. No, 6, then 7, I think. You tell me.
7 lordship here, only the joint ventures can, lordship in the rich petition, the full tender documents are not.
Wait it. Where is the site verification certificate required?
My lords will have the site verification certificate.
Where?
My lords, at page 58 and 68.
No. I'm asking you, where is the clause for site visit?
My lords, there is a declaration. If my lords will have page 57.
What?
My lords will have page 57.
No. I'm asking you, where is the clause for site verification?
My lords, the integrity agreement has an undertaking for site verification that every bidder has to submit.
No. There has to be a clause. Where is the clause?
My lords,
Where's the clause?
My lords, my submission is that the integrity agreement requires every bidder to give an undertaking in a prescribed format.
No, Mr. Counsel. I think we should dismiss your petition right away.
No, my lords.
No. This is a case where we should dismiss it right.
My lords, my point is very
You had
simple.
enjoyed the stay for 1 day, for 4 days, you should be happy.
No, my lords,
But
there
yeah,
is
stay
that the
from the
fact that,
spot is very difficult, Mr. Chaudhary. You got it, very good.
my lords, my point
Now,
is,
matter ends.
my
You have
lords,
not enclosed the entire document.
my lords, may just hear me for 1
Court was
second.
very strict on this aspect, and that day also I was.
My
discussing
lords,
what
there is
your-
absolutely no
what
suppression.
your-
I am
what
happy
your
to furnish the entire bid
petition
document.
filed from Mr. K. Chaudhary's chamber.
My lords, the only reason I did not annex the entire bid document is because it is too long.
And the moment you don't enclose anything, the video conferencing link also, your voice also disappears from here.
My lords, may just hear me.
Mr. Chaudhary, can you hear? No, we can't hear.
My lords, may,
Where's the clause in the contract?
my lords, the clause in the contract is 22B. What I am alleging, my lords, is violation of the integrity agreement.
Mr. Chaudhary, we can't hear anything from you. First of all, you have not enclosed any document.
My lords, I have
Can't hear
only.
you. The opposing counsel can't hear you. Do you hear anything? No, he also can't.
My lords, may, if my lords may can't hear me, I will appear physically in this matter. My lords may just give me one more date.
No, this is why I'm saying, Mr. B. Chaudhary. Mr. R. Chaudhary, you don't say anything. There are two aspects. First, there are many judgments also passed by this court on the aspect where submissions have been duly made, that particular person has to visit. And on that basis, on the last occasion, there was one matter of Mr. K. Bhuiyan, wherein the specific stand which was taken by the PWD, were you there?
Yes.
that this particular person who did not go, his representative go. There were two petitions. And I've dismissed it on that ground. Don't you remember that? Yes. Now, this is on the basis of clause 6.1, wherein say site visit by the bidder is mandatory as the site is full of numbers of existing structures. This is the clause. So therefore, if one of the persons have visited and one have not, because it is apparent both have used the same site visit certificate photograph. So if that be so, so therefore one is bad, one did not visit. Secondly, if both of them submits together, how do you take care of clause 2, bracket 2, small b?
The basis of the record that was
In fact, you should blacklist these people. Don't you think so? Integrity pact. Isn't it the requirement?
it is very
Your specific stipulation in the contract says that if you violate the integrity pact, you will be blacklisted. And on the other hand, you have been very good with them, pally with them. Why?
Lordship, strict compliance of that integrity pact, Lordship. Then the whole tender process go because the petitioner also, Lordship, from the bid document it's available. Someone else has gone, not the bidder himself.
Cancel it. Go for a fresh one. You want to go. If he has already mentioned that he is a representative and your assistant executive engineer does not go alone, it is being done at the behest of the executive engineer.
Yes.
So the executive engineer must have asked him, and thereby allowing the representative to be there makes it very clear that you have permitted the petitioner person to be there and accepted him. That is your thing. But the fact remains out here that these two persons, one goes on the basis of no visit, and the second goes on behalf of the integrity pact. And do you have any urgency in doing the work, or we can delay it for filing your affidavit? Which one? I think we have to issue. If I can't set aside because 3 and 4 is there. I have to issue notice. I didn't stay the entire thing because you said that you were going to get it on Wednesday. I've looked into the records, but without their presence, it would not be proper to do so. So in the meantime, Mr. R. Chaudhary has to file that entire.
We will file the entire tender document, my lords.
Lordship may give me a short time. In the meantime, whatever.
And I will also appear physically on the next date,
You
my lord.
also inform those people who have violated the integrity pact to also come soon so that we can finish up the matter early.
Absolutely, my lords, absolutely.
pursuant to the order passed by this court on 7/11/2025. Mr. B. Chaudhary, the learned standing counsel of the PWD department, had produced before this court the records. From the records, it is apparent this court had the occasion of perusing the records, including clause 6.1 of the tender conditions. From a perusal of the records, the allegations which have been made by the petitioner insofar as submission of the same site visit certificate by both the respondent number 3 and 4 appears to be prima facie correct. This court inquired with Mr. B. Chaudhary, the learned counsel appearing on behalf of the PWD department, as to whether one of the respondents should not be debarred, taking into account clause 6.1, which mandates that the bidder has to visit the site, which mandatorily requires the bidder to visit the site. And the second, apart from that, the other bidder have violated clause 2, bracket 2, small b of the integrity agreement, which stipulates that there cannot be any cartelization by giving in respect to certification. Mr. B. Chaudhary submits that he will file a short affidavit in that regard. Taking into account the above, this court therefore finds that this is a fit case for issuance of notice upon the respondent number 3 and 4. Issue notice upon the respondent number 3 and 4, making it returnable on 5th of December 2025. The petitioner is directed to take steps by tomorrow by speed post. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. It is further directed that till the next date, the interim order passed on 7/11/2025 shall continue.
I'm very
The
grateful,
affidavit to be
Lords.
filed by the respondent PWD shall be on or before 21st of December 2025. Full stop. In addition to that, on the next date, the records also be again made available so that an attempt can be made to dispose of the writ petition. This court further directs the petitioner to bring on record by filing additional pleadings the entire contract documents.
Can it be there before 5th or after 5th? I will not be available on that.
Would you be available on 8th?
Yes.
I'm very grateful, my lords.
This is a lordship.
What is it?
My lord, here, my lord, we have paid for direction to the respondent, my lord, Panchayat for issuance of tender, my lord, for settlement of a cattle market, my lord. It comes within the jurisdiction administrative control of Taringpur Panchayat, my lord. It was earlier used to settle, my lord, through tender process. That continued in 2024-25, there was no settlement, my lord. An extension was given to the leasing, my lord, to run. And prior to the extension, my lord, lapse of prior to the start of our financial year, we approached the respondent, my lord, with a representation requesting them to load tenders, my lord. But they have rather, my lord, they have.
You want which market to be done?
My lord, I want market to be settled through tender.
Sial
Cattle market.
cattle market.
Yes, my lord.
Now they have not issued the notice inviting tender.
Yes, my lord. Only, my lord, I have filed a representation, my lord, along with the local farmers and people, my lord.
So they have issued for Sialtech general market, Sialtech
Yes, my lord.
Badar Perry.
Yes, my lord.
But
Only
not for Sialtech
cattle market.
Cattle market.
Yes. Thereafter also we met them, my lord, and they said that we are in process. But my lord, already 2 months has left.
So you want to just give them a push by way of the recipe. So that tomorrow they come up and say that we are not going to do it, and you say that it is infraction.
No.
You filed 3 petitions earlier, na? Similar type.
That is, my lord, for another cause of
matter,
action, my lord.
yeah.
That is not connected with this matter, my lord.
Okay. Madam, you just find out why you have not done it. Most probably because of the Cattle Preservation Act.
This must be the reason why, because there are various now requirements.
Restrictions are placed, my lord, in selling, buying and selling of cattle also, my lord.
That is the problem. Okay, issue notice making it returnable on 24th November 2025. Ms. So-and-so accepts notice on behalf of the respondent number 1, 2, 4, 5, 6, 7. As regards the respondent number 3, Mr. MCT accepts notice. Extra copies of the writ petition be furnished to them during the course of the day. Petitioner herein is aggrieved in not issuance of notice and tender for settlement of the year 2025-26. For the year 2025-26 for settlement of the Sialtec cattle market under the Katigora development block in the district of Kachar. Full stop. The respondent shall apprise this court as to why no such tender proceedings have been initiated for settlement of the state market on the next.
Item 52,
Lordship shall take up production list item 1 together with this.
Hmm?
Item 52. Connected matter is production list item 1. It's my senior with us.
Yes, Mr. Gustami, what is the matter about?
It's an little interesting question I am finding. Look, NRL is an entity, as a corporate entity. It has another role because the gas, Indraprastha Gas Company, it's a 5 PSUs are the shareholders. That means they are all joint venture company. Now, so far as joint venture company is concerned, the respondent here, he was blacklisted, of which, my lord, the NRL is also a party, obviously. Now, when NRL has started issuing tenders for its, for getting the hired vehicles, the person who was blacklisted is a tenderer. Now, the question is, my lord, whether in NRL policy also blacklisting listed candidates are not encouraged or not allowed to participate. Now, the question is, my lord, when he was blacklisted in the other company, whether NRL in processing this tender is required to keep an eye on that and at least give a relevant consideration in the process of doing that. They have not finalized the process as yet, but
Now, who is blacklisted here?
because fund
Who is blacklisted here?
R5 below,
So,
who is L3.
Subrasi Tours and
Yes,
Travels.
yes.
So they are blacklisted, but they have been allowed to participate.
Participate, and they have been now in their website, they have shown
As-
that they are L3.
And you are?
Empanel.
And you are L1.
No, we are not
Right.
there because they will select 3. We don't come under that first 3. We are 5. No?
Okay.
So the question is now whether they will be, they have not taken the call. We have sent a letter after we got this information because it came out.
And what about the other two? Sharma and Roman Pukon?
They are not blacklisted. They
So they are L1 and L2.
L2.
So if the L3 goes,
Yes.
L4 comes in.
Yes, that is what their system is, that procedure.
But you are L5.
No, you have to match the price, lowest price. So that option is given. Page 40, that system is there. So you have to match that lowest bid.
Hmm.
If you don't, then the next one will come in place. So it's a question of a gamble in a way.
L5 will come into the picture, L4
If you refuse it. So that is another thing, but
Everybody has a chance.
everybody will.
Everyone will have a chance.
Yeah.
The L4, L3 refuses
So
to match the L1 price.
we wrote them a letter. And
Why
them-
there are two petitions? Why
because
there are two?
one
repetitions?
other, another petitioner.
He's what? L5, L6.
He is 4. L4.
You are L4, so you have a better right.
Yes.
If he doesn't match, we come.
So the question here is whether a person who has been blacklisted
The
by
joint
one
venture.
of any company,
No, Malak,
In the joint venture company,
Okay, but kindly turn to page 47. That is my limited instructions which I have right now. 14.26 clause. 14.26. Agencies who are in the holiday is blacklisted by any government / PSU.
where?
47, Malak, that should be taking up item number production list.
No, the other one, Lokhi Prasad Bora.
6403.
Page number 14.47, I think. 49.
14.26.
14.
Yes. Who are in the holiday days of the PSU or against whom there is an adverse report on me, the offer would be rejected.
So whether IGTL is a PSU or not, that was the understanding of the IGTL is not a PSU. The joint venture of 3 PSU, I mean, 4 public sector undertakings, it itself is not a PSU. That is why the decision was made.
So we have sent them a,
Whether IGCL is a party,
IGTL is not.
then only we can know. Can we decide that whether it is a PSU or not a PSU?
joint venture is not a
Joint
party.
venture of 5 PSU. It is a joint venture of 5 PSUs, Oil India Limited, GAIL, IOCL, Numoligar and ONGC.
No, understood, but a joint venture is a different entity. It has been held by the Supreme Court on
That
various
is what
occasions.
our understanding.
My also understanding appears to be same. But without the IGCL being a party, would it be proper for this court to declare that it's a PSU or not a PSU?
No, we are not on that. They have passed the order of blacklisting. Only question is, when NRL is a part of that joint venture,
NRL says they are not PSU. Do you,
PSU,
no, you are saying IGCL is not a PSU.
no, ITCL is a conglomeration of these PSUs.
No,
It is a
understood,
PSU,
but
obviously.
they say that
have
it is not a
that.
PSU.
We have given that.
Now, if that
It
is
is
a,
at page 121, we have given that chart about Indraprastha Gas Limited. Indraprastha Gas Grid Limited, IGCL, is a joint venture company promoted by all these 5 companies, IOCL, ONGC, GAIL, Oil, NRL. IGL was incorporated on so-and-so towards implementing hydrocarbon vision of 2030 for Northeast India, released by Ministry of Petroleum and Natural Gas in 26. Hydrogen carbon so-and-so envisages Northeast India economic development by all that.
but Mr. Goswami,
Yes,
if you may appreciate what I am trying to say,
yes, Vivek.
if I hold as per NRL that it is not a PSU, because their terms and conditions are if it's a government / PSU. I can't incorporate as a 226 court another condition. Can interpret that particular condition that it would become a PSU or it may not become a PSU. It may become a government, it may not become a government. But would it be proper on the part of this court without knowing the stand of the IGCL? Because you see, that has a far-reaching consequence. No, why I'm saying it has far-reaching consequences. Otherwise, an IGCL blacklisted firm, any order passed herein, an IGCL blacklisted firm
which may have a lot of repercussions, becomes useless if they are not a PSU like all the other entities like oil and everybody say that we only go by the PSU of the government. So the effect of a blacklisting order of an IGCL would become redundant. So don't you think that they should be made a party so that let us go to know their stand also, because this is a clause which have been mentioned out there wherein your specific statement is it comes within the PSU.
I'm saying it's a joint venture, Miller, of these 5 PSUs.
No, so therefore 5 PSU joint venture, would it be, because the joint venture is a different entity. There's no quarrel with that proposition. So the question of looking into various other aspects pertaining to lifting the corporate veil or all the aspects of the matter, unless you say that it comes within the PSU, then it is a different thing. Otherwise, you don't have a case.
No, Miller, so far as Indraprastha is concerned, as the document itself indicates, it's a joint venture of 5 PUCLs. Page 121.
We are not on it, we are on whether NRL as a constituent of 37 refers into clause.
So, what is the public, whether it is, because their term says it is government or PSU.
No, your lordship have a look at the page 37 for a minute. This is by NRL.
37.
Yeah. It is 30. Notice inviting tender.
Clause 10.
Close 10 at page 36 below.
Page 39.
Page 39.
I'm looking into Mr. Goswami's petition now.
Yes.
What is his
That
name?
is,
Jharona
then it is below page 37 I am trying to show.
37.
Yes.
Offers from blacklisted agency will be rejected. A self-declaration from the bidder needs to be submitted as per prescribed format, Annexure 1 attached with the tender document.
Yes.
Where is Annexure 1?
That is at page 59 below.
59.
59.
Party to a joint venture blacklisted, then you have to read that as NRL.
Ministry of Petroleum and
So here only NRL and ministry
Yeah.
have been mentioned.
clause says also PSU.
To it, if NRL is a shared ownership of a joint venture to a decision, then how do you not treat NRL as that joint venture and not, it's a simple thing, NRL can't for lesser interest blacklist, and then for a greater interest, for 100% not blacklist the same thing. NRL remains the same, whether it's a joint venture or it's a independent company. It is down with a paragraph. Then how can NRL be independent?
What is the status of the tender?
Miller, we have drawn their attention to their own letter of that blacklisting. They have not taken any decision. Possibly they are under consideration. Huh? No, because they have not, because the earlier contracts are running till January, I think. Therefore, they are taking their time possibly to consider what we have said. You can have your instructions.
You bring on record your standby filing affidavit, no say, nothing. Look into it. As to, because this is a question of interpretation as to whether, because you see, clause 10, prima facie would not be attractive taking into account annexure 1. Annexure 1 only refers to the Ministry of Petroleum and NRL.
In fact, that is in line with the policy. Our policy says that only if it is by NRL or the ministry, we will
So
not.
the question is whether a joint venture, which is will also a blacklisting done by that firm, can also be brought within the ambit of clause clause 10, as well as clause 23.1 of 14.26.
14 point.
That's the question.
That's it.
Issue notice.
Because
Because we let us hear them also, the other side, because that would be necessary. 1 and 3 and 4, they are just being made. The question is against number 5.
5 years, obviously, is the
Issue notice. Heard Mr. P.K. Goswami, the learned senior counsel, assisted by Ms. G. Goswami, appearing on behalf of the writ petitioner in WPC number 6403 of 2025. And Ms. B. Chaudhary, the learned counsel who represents the petitioner in WPC number 6412 of 2025. It appears that in both the writ petition, the parties, the respondents have been similarly arrayed. Mr. You appear, na? Mr. S.S. Roy appears on behalf of the respondent number 1 in both the writ petitions. And Mr. N. Dekai appears on behalf of the respondent number 2 in both the writ petitions. The counsels appearing on behalf of the petitioners in both the writ petitions are directed to serve extra copies of the writ petition upon Mr. S.S. Roy as well as Mr. N. Dekai by tomorrow. তার আগতে issue notice করব, issue notice in both the writ petition returnable on how long?
I'll require a week or 10 days time to file my.
Okay, let's have it on 27.
We'll have it in December, December, that will be better.
Okay,
2nd of December.
No,
2nd, 3rd, 4th, 5th. When?
Second week will be better.
2nd week, okay. On 8th of December? Because I'm not passing any stay, so that is why.
Because they have time till January, that's why.
Okay.
I'm not-
On 8th of December, 2015.
Yes,
Okay. On 10th of December, 2025. As regards the respondent number 3, 4, and 5, in both the writ petition, the counsels appearing on behalf of the petitioners are directed to take steps by way of speed post by tomorrow. In addition to that, the petitioners are also given the liberty to effect service upon the respondent numbers 3, 4, and 5 in both the writ petitions. By Dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The issue in both the writ petitions are one and the same. Except certain minute factual differences. The respondent number 2 had issued a notice inviting tender for empanelment of agencies for hiring of vehicles on call duty / ad hoc duty service for Numaligarh Refinery Limited at Numaligarh location. In terms with clause 10 of the notice inviting tender, it is specifically stipulated that offers from blacklisted agency would be rejected. And in that regard, a self-declaration from the bidder needed to be submitted as per the prescribed format in Annexure 1 attached to the tender document. This court have perused the Annexure 1 to the tender document, wherein the reference made therein, wherein the reference insofar as the blacklisting is concerned is in respect to holiday listing oblique blacklisting oblique debarment orders issued by the Numaligarh Refinery Limited bracket NRL or Ministry of Petroleum and Natural Gas bracket M small o PNG bracket closed. Another clause which is of relevance for the purpose of the present dispute is clause 14.26, which stipulates that agencies who are in the holiday list oblique blacklist of any government oblique PSU or against whom there is an adverse report on committing criminal offense, their offers would be rejected. In the backdrop of the above, the issue which arises, the factual aspect which has reason to the dispute is that the respondent number 6, 5, is being alleged that the said respondent have been blacklisted by
Indraprastha Gas Grid Limited, ITPL.
by a company. It's a company. In the name and style of Indradhanush Gas Grid Limited. Which is a company promoted by Indian Oil Corporation Limited, Oil and Natural Gas Commission, GAIL Oil, and as well as Numaligarh Refinery Limited. Mr. P.K. Goswami, the learned senior counsel, leading the argument in one of the petitions submitted, that taking into account that the Indradhanush Gas Grid Limited had blacklisted the respondent number 5, the said blacklisting would duly operate within the ambit of clause 14.26 of the tender document. For contrast, Mr. Ndeka, appearing on behalf of the Numaligarh Refinery Limited, submitted that a perusal of clause 10 read with the annexure 1 of the tender document as well as clause 14.26 would show that the blacklisting is confined to government oblique PSU, and as per his instructions, Indradhanush Gas Grid Limited is not a PSU, and as such, the clauses 10 as well as clause 14.26 do not operate to debar the respondent number 5 from participation. It is the opinion of this court that this very aspect would require further deliberation, and as such, deliberation and pleadings would be required from the respondents, more particularly the respondent number, and pleading and appropriate instructions in the form of pleadings would be required from the respondent number 2 as well as the respondent number 5. Considering the above, Mr. Ndeka submits that he would be filing his affidavit on or before 1st of December. The respondent, number 5, is also given the liberty to file the affidavit if so advised. At this stage, this court is not inclined to pass any interim order. However, depending on the instructions so produced by way of pleadings, this court shall duly consider if any interim order is required on the next date.
10th, Lordship is fixing on 10th December.
10, 12.
10th. And Milord, your Lordship may add that additionally, we are really coming under clause 10.
Huh?
Clause 10,
I mentioned clause 10.
that is,
I mentioned your cases comes under clause 10 and clause 14.26.
no, he is saying 14.6, 26. We are basically trying to come covered by clause 10. It will be same in the argument.
It will be same. Because anyways, clause 10 has
Basic-
a direct relation with annexure 1.
Yes.
Yes.
And basically, Milord, the idea is that if you, as a company and as a part of that gas company, thought it fit to blacklist for 2 years or 3 years, would you, when you are issuing your tender for a similar thing, not take into account that blacklisting? That's the bigger issue, Milord, and that is
But
something
Mr.
which,
Goswami, the thing I would have, if I was their author, I would have definitely considered it. But the problem remains of this court being not there.
yes, it. Anyway, it's an interesting question.
Last
Your Lordship.
motion item 53.
Leave it.
Yes, what is this?
May I please, Your Lordship? Your Lordship, I stand on behalf of A. Kakoti, standing counsel AIBC. Your Lordship, the council is in Kohima for a matter, Your Lordship. So I pray before this honorable court to release the matter tomorrow or a day after as per the convenience of this honorable court, Your Lordship.
Lordship, in this matter, I was disqualified from technical bid and was not allowed to participate in e-auction based on the reasons that I have not submitted the documents required for technical bid. But in
You
fact,
were
those-
disqualified on 25/9.
Lordship,
You were disqualified on 25/9.
I was disqualified on 25/9. Lordship, after that, I have wrote a clarification letter to the respondents, which they responded on the last day on 9/10/25. And 10/10
Now,
was
what is the status present?
present status is Lordship has entered in 2 writ petitions where the entire auction process has been stayed.
It's
it
state.
stayed.
So
and it
then
is posted
we
on
can have it day after?
Lordship.
If there is already a say, then you are already protected.
Yes, Lordship. Or Lordship may issue notice and post to it along with those matters.
Let us hear him on
Lordship,
list the matter on Friday.
Friday.
I would like to Lordship. Replicating item 16.
Yes, what is it?
My lord, we had filed a writ petition, my lord. Wherein, my lord, we have challenged the order of the ombudsman. Where the ombudsman has held that we are not allowed to, the APDCL is not allowed to incur bill after the period of limitation. But we are contending that as per section 56(2) and the Supreme Court judgments, we are allowed to do so. So, my lord, first I would like to raise a fact.
Where is the interim? You are asking for interim order vacating.
No, no, he is asking.
This is my application. For what?
I am the paid petitioner.
Interim order passed by this honorable court on the grounds among others, my lord. The read petition itself is not maintainable. Huh? Who has filed the read petition?
APDCL, my lord.
APDCL filed this. Selling the judgment and order given by the learned electricity. Enforcement. Then? And we are before your lordship, filing this application for vacating the interim order passed by this honorable court on the grounds amongst others that the read petition itself is not maintainable. Then, the read petition itself is not maintainable on the grounds, my lord, that the read petition itself is not maintainable. My lord, your lordship is aware. As far as the ombudsman is concerned, he is
a non-adversarial adjudicator of disputes between the citizens and the government agencies. So the award given, because he acts just like a conciliator or mediator, is provided in the Consumer Redressal Forum. So the award given by him can be assailed only on the limited grounds as enshrined under section 34 of the Arbitration and Conciliation. There is not a single averment in the writ petition showing that he misconducted, there is any fraud, or there is any violation of any public policy. Now, my lord, the writ petition is constructed.
So you say that electricity ombudsman order is passed under what provision?
That is under the Consumer Redressal Forum.
There is special,
That is the regulation.
there is special regulation.
Aimed in exercise of powers conferred under section 42 of the electricity.
42 of the?
Under
Electricity.
section 42, subsection 5
Of the electricity.
of the electricity.
My lord, I have the entire act.
Anyways, we do one thing, we'll take it up on some other day. 42.5.
Subsection 42, section 42, subsection 5, my lord.
Every distribution licensee shall within 6 months from the appointed date or the date of grant of license, whichever is earlier established a forum for redressal of grievances of the consumer in accordance with the guidelines as may be specified by the state commission. What is state commission?
Assam Electricity Regulatory Commission.
So they are, therefore, this electricity ombudsman is being made by them.
Yes, my lord.
Yes, my lord.
This is the guideline.
And this is the,
This is the regulation.
Now you say that they having decided it, it's an award?
Within the meaning of section 34 of the arbitration.
How?
Because he acts just like a conciliator or mediator. And as against the award, there is a provision under the regulation itself that if they finds any difficulty in implementation, they can approach the Assam Electricity Regulatory Commission. That they have not done. Secondly, in the arbitration, in the order passed by the learned ombudsman, they have given the option to approach the audit party. Or because this bill is generated because of the audit objection. There was a audit objection, and the stand taken by them was that whatever the APDCL has done, that has
Okay,
done.
we let us have this on some other day.
my lord.
When do you want it? This, you have filed your pleadings?
My lord, he has not filed affidavit in
You know,
opposition
this
in case.
can be treated as affidavit in opposition.
Heard Mr. S. P. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. S. K. Kejriwal, the learned counsel who appears on behalf of the proponent number 1 and 2. Mr. S. K. Kejriwal, the learned counsel appearing on behalf of the respondent number 1 and 2, submit
Two.
two.
Yes. For one, he is.
One is what?
Ombudsman, my lord.
Appears from here as stay for respondent number 1 and 2. Mr. S. K. Kejriwal, the learned counsel for the respondent number 2 submits that the application filed for vacating being ISC number 2168 of the 2025 be construed as the affidavit in opposition insofar as the repetition is concerned, and the respondent number 2 would not like to file any additional pleadings. Mr. S. Day submits that the respondent number 1 ought not to have been pleaded, taking into account that the state authority had exercised jurisdiction, had exercised judicial had exercised powers in consonance with the Assam Electricity Regulatory Commission (Redressal of Consumer Grievances Regulation 2016), which have been framed in terms with Section 42(5) of the Electricity Act 2013. Taking into account that the matter would require an in-depth analysis comma. This court, and there is also an interim order pending. This court fixes the matter on 4th of December 2025 at 2 p.m. for final disposal. Interim order partially shall continue till the next date.
17.
This book, the moment you give a book, it is being confiscated.
Or I will share another copy.
Yes, what is
May I
this
please,
IA for?
Lordship, we are filing this writ petition, my lord, by challenging one settlement order, Parghat settlement order. Balaswar Matragola Parghat, which is located in the district of Bongaigaon under Srijangram Revenue Circle, my lord. In this case, we are challenging the impugned order on the basis of, my lord, mainly one ground, that is, my lord, clause 13 of the tender notification, my lord. In my writ petition, my lord, page 22, Assamese vernacular, my lord. Got it, my lord. Clause 13.
Oh, yes,
Yes, my lord.
I remember.
Yes.
Now you have a clause 47(1). So, he's right. You could not have rejected it. And more particularly, 47(1), Rule 47(1) as amended now, makes it very clear. Writ petition should be allowed. Yours be set aside.
Because my lord, in this case, my lord, last 3 years settlement was not met.
So,
my lord, my assumption with your lordship, my lord, since my lord, last 3 years settlement was not met, but there is a my lord, the cabinet decision that the tender should not be my lord, exorbitantly high. But in this case, my lord, the government value was my lord, 1,21,970, and he offered my lord, 2,99,900.
if he doesn't pay, then very well they will take action against him. What is wrong?
That is true. But since my lord, as per my lord, the amended provision, that the maximum rate should be my lord, within 10% of the last 3 years settlement bill. But the settlement was not met.
So,
But so my lord,
that day only you argued that 47
yes, my lord.
with Mr. Surajit Datta.
Then my lord,
Bad case. Allow. What? Allow. Goldie. Pass the order. Allow your writ petition allows, I dismiss.
Must.
You'll get the order on Monday.
For admission item 88.
उसको रखी थी कागज अपना Yes, what is this? Payment made.
We invited them, the checks are ready now, they refuse to take the check.
No, I'm coming, give me the copy, one of copy, Lordship. What they are asking for, 23,000, Lordship.
I therefore said, have I not said to you on the last occasion when the matter came before me?
Lordship.
The moment you get the money, accept it under protest and then file section 16. Didn't I tell you?
Section 15. 15.
15 or 16?
15 of the rules, my lord. If there is a dispute with regard to the quantum of compensation, they can approach the commission.
Lordship, I would.
You're not receiving the money. First of all, you want more money? The authority can.
Not the more money. They wants this dispute to be arise so that they further get the delays, Lordship.
Then
And
interest
they
comes, Mr. Counsel, the interest comes in.
Lordship, let me place one order, Lordship, of this or court, Lordships, of dated Lordship 26/7/17. Thereby they place an instruction whereby they stated they will not erect any pole, and the stay order has been granted by this your lordship. Now, if they come that they had erected the poles, that means they are defying the order of your lordships.
The interim order was.
So interim order is there, they are defying your lordship's order. So now they are come there, we have constructed, now we will give this, take this 23,000, the compensation amount now go to the dispute and appropriate forum, lordships. This is their case.
Respectfully, my lord, the interim order was not to energize the line, my lord.
26/7/17. So fully functional, the they are, it is admitted position, they are fully functional. 2617 order, lordships.
Who appears on before me on the last occasion on 7/8? Who is Mr. M.R.A. Kundu?
Lordship, my name is Shun, but my junior has appeared on that day.
He appeared.
She
He had
appeared.
no problem when this order is here. The petitioners herein are aggrieved by the actions of the way in erecting poles within their private. The fact that STPR are erected within the private lands are not disputed. The question arises whether such a course of action is permissible. It is seen that by the order dated so and so, taking into account the submissions so made by the learned counsel here, that a month's time would be required to initiate process for payment of here, fix the matter today. So this is how it happened. Then on B. Soikial appearing for A. Kundu. Mr. B. Chaudhary appearing on submits that he needs a month's time to enable respondents to initiate process for payment of compensation to the petitioner. Why on earth did you agree?
That is there, lordship.
Then?
That is there, but
Forget about all these things.
but your lordship's order has been deferred by them, lordships.
We will consider later on. It has defied our order, we will consider. It is you have pointed out, we have seen it. We are happy. Take that money, file with 16.
Section 50. Because I have the checks, madam.
Lordship,
They will, lordship, by this way, lordship, they will all 23,000 lordship compensation amount.
Lordship, why you are not understand?
Yes, lordship.
This court cannot fix the rate.
Lordship, I understood, lordship, but they let them at least place the assessment or assessment, how they made the assessment, let this place.
Those were
At least, lordship, that may be placed here, lordship.
Huh?
On assessment, how they made, lordship.
Where?
Assessment, the Lot Mandal had communicated to the Deputy Commissioner Manoj and he had made the assessment.
The
I have
notified
received-
zonal value of Sali land of the land in village so and so as per BTC Kokraja is 1,000 per big.
Let me give the copy,
One
let
lakh
me, let me take one instruction, let it be in the next day, lordship. If, I
had
have
placed those
not received
instructions.
any copy, whatever placed before your lordship. Let them place the, let them give the one copy to, that courtesy should have, lordship, lordship. At least one copy of
I have,
how
it-
they.
I have already marked it as Y.
Yes, lordship.
Mr. B. Chaudhary, the learned counsel, standing counsel of the APDCL submitted that the amount of 23,000 312 was paid to the,
They were called to the office, madam. They refused to
the
accept the check.
petitioner submitted that the petitioner were called to the office to hand over the check of the amount of rupees of various amounts totaling to rupees 23,312. However, the petitioners refused to accept. This court, where's the rules?
Rule 15, right? Determination of dispute or difference by appropriate commission.
This is only, lordship, they have not booked the assessment, lordship. This is only the amount, lordship.
No, where's the appellate provision? Reference provision.
Determination of dispute or difference by the, when a matter is brought to the appropriate commission for determination under these rules, the matter shall be determined by the, within a period of.
Where's the appropriate commission?
Yes, is the ARC, man, AERC.
ARC will look into it.
Yes, ma'am.
Where is that? Whether licensee make default in pay, you have determination difference of year by appropriate. When a matter is brought to the appropriate commission for determination under these rules, the matter shall be determined by within a period of 30 days and after hearing the parties concerned.
Yes. Now, Manoj, would kindly see, rule rule 2D, Manoj, commission is defined as the ARC.
has already been so and so, but have now refused to accept. Mr. A. Kunduna,
Yes, sir.
the learned counsel appearing on behalf of the petitioner submits that the petitioner are not aware on what basis such assessment was carried out. He would therefore like to apprise the petitioner on that aspect. So taking into account the above, list this matter on 1st of December 2025, on which date an attempt shall be made to dispose of the writ petition. To have a look at this,
Lordship.
whether this will be done. What are you doing out here? I mean, you were having line.
They had constructed the poles, Lordships. Without the consent that they are, without the taking acquisition, Lordships. Following the proper rules, Lordships. This rule has been quoted by 3, license to carry out the works, Lordships, in my page 5, Lordships.
So the determination having been done now, the payment has to be made as per the Right to Fair Compensation Act.
Yes,
That
yes,
I
they have
would-
to.
perhaps that would require.
No, anyway, you take that money, I will pass those orders, then you go there and fight it out with my judgment.
The checks are with me, my lord. If my learned friend wants to accept them, I have the check with me today.
I can't, Lordship.
No, not necessary to accept it today because his time will
My
run.
prayer would be, Lordship, at least let them place the assessment. How this assessment, thus only 6,000 they are
They
They
are
are
giving
saying
it
1
rupees,
lakh.
Mr. Counsel, they are doing it at 1 lakh. You
Yes.
therefore make an argument that whatever may be the provision, under no circumstance it can be less than the right to fair compensation, which is the mandate. And there are 2 judgments of division bench of this court.
yes, sir.
One from Arunachal, one is by the Chief Justice, and I think another one, another judge. There is a division bench judgment coming from Mizoram, where the question arose out here whether in there in this particular case in Arunachal, the case was whether in respect to Jhum cultivation, right to fair compensation will apply. And in that case, in respect to, because under 371G, the Mizoram government have not accepted that, have not adopted the right to fair compensation. Then also the single bench as well as the division bench directed payment. So therefore, your case will also come within that. So therefore, the assessment of compensation has to be made accordingly. So you make those submissions for the next.
Lordship.
Okay.
Lordship. I'm thankful, Lordship.
May I please, Your Worship? Yes. Matter pertains to the retail outlet dealership. The petitioner was selected, Lordship, by draw of lots, and accordingly, the communication was given to the petitioner, and he was directed to deposit the required amount, and he had deposited the same. But subsequently, by the impugned order, the petitioner was not considered for opening of the retail dealer outlet. So this is the basic issue, and they have come up with a new plea that the land which has been provided by the petitioner is the outside the advertised.
Where is the land offered by you? Document?
Lordship, all the papers I have not annexed, but the relevant communication, if your Lordship.
No. Where is the land document?
Land documents, these are all voluminous papers, Lordship, that's why I have not annexed.
So how do you have a case?
Because Lordship, I'm just.
Your rejection is on the basis that the long document which you have submitted,
exactly,
it do not bring you within group 1 or group 2.
Exactly, Lordship.
So, and you have not enclosed that document, how can I look into this?
Lordship, then first of all, the communication that is annexed.
And they have filed an affidavit in opposition long time back.
Yes,
So
that was,
nothing is there. Interim order validated, vacated, I suppose, no interim order.
interim order was otherwise not.
Subject to outcome of the.
Subject to outcome. If your Lordship gives the direction, I'll enclose all the relevant papers. Lordship. These are all-
Kindly see the impugned order, page 24.
This would be this. You have settled it. Yes. Somebody running it.
No, that is not.
That is not done.
That is not done because, my lord, pendency of this writ petition.
Okay, I'll make it clear, the pendency of the resolution shall not bar you to.
In fact,
I don't
when
have the time,
evaluation was
otherwise I'll
done in his
dismiss it.
presence, it was not objected by the petition.
Huh?
When evaluation was done in presence of the petition.
No, we are not disputing the land.
Now, what is
acquisition,
the
Lordship.
ground on which you rejected?
My lord, it was not, as per the advertised page, my lord, location. Page.
Annexure
Is
4.
beyond the
Annexure 5.
advertised stretch
Phase
of
20
kilometer 865 to 875.
yes.
Huh?
Land offered is beyond the advertised
From
range.
kilometer 4, 865 to 875.
This is the advertised area.
Towards increasing chaining. So it is not there. His
My-
location is where?
My lord.
Lordship, my representation will clarify the entire aspect of the matter, Lordship. Annexure,
Your representation.
Annexure
don't
9,
know.
page 25. Representation relates with my documents, Lordship, because the Annexure 4, if your Lordship kindly have a look at this Annexure 4, Lordship, I was considered. And why I was considered? Because I placed all the papers. By verifying all my papers, Lordship, I was considered, and accordingly the
No,
communication.
no, that is okay. At that point of time, they don't look into much. When the land verification happens on spot.
Exactly,
that is
Lordship.
how it is being done.
And I,
In presence of the petitioner.
no, I'm not disputing that it is not in
I
my
think
presence.
division bench may help you out. Heard Mr. SP Chaudhary. to
Lordship,
learn
then
example.
give an observation. In the meantime, I will submit all the relevant documents,
No,
Lordship.
file all before the.
Pendency of the writ petition, if the order is their pendency, they can proceed with the settlement. In the meantime, if the documents are there, I will place all the papers before this honorable court for proper adjudication.
They filed the affidavit in 2022.
No, I'm not saying about the affidavit, Lordship. What I'm saying that I'm having the relevant papers to establish my case, Lordship. I will place all these as additional affidavit, Lordship, not the affidavit of.
You have not filed the additional affidavit. All
No,
this
I will
while.
place all the relevant papers, Lordship, the
No,
land.
From these
documents.
materials, it is not there.
But no affidavit in reply has been
No,
filed
SP
against my
Chaudhary,
affidavit
learned
position
counsel
long back.
appearing on behalf of the petitioner, Mr. D.K. Sharma, the learned planning counsel, who appears on behalf of the IOCL Limited. The petitioner herein has approached this court challenging the decision of the respondent authority dated 13/12/2019, whereby the provisional selection of the petitioner as a group one,
Yes,
Yes, Lordship.
as a group one category candidate was rejected. Full stop. It is relevant to take note of that a notice inviting tender was issued for the purpose of settlement of various retail outlets, including a retail outlet situated at
Kakopathar, to Madhav.
So where is that advertisement? No advertisement also.
I am basically relying on Annexure 4 and Annexure 5, Lordship.
Don't rely on this. Where is your advertisement? Nothing is there. Nothing is there. Where is the advertisement, Mr. Counsel?
That was the advertisement, if a Lordship, that's why I made a mention about Annexure 9, Lordship. Advertisement inviting application for award of RO dealership at Kakopathar to Madhepur on National Highway 15.
No, because they are going on the question of saying it. Where is the advertisement?
Copy that is not an annexment.
Why you are claiming on this page 39?
My lord,
Isn't it your case that there is a mention of a chainage?
lordship may kindly see the page 13 of my affidavit, where sketch has been drawn. Annexure 8 AO2, page 13.
Where is the advertisement? Advertisement stipulates the year.
That is not disputed, my lord. The area is not disputed by the petitioner or I, my lord, authority.
So why the petitioner, isn't it the case of the petitioner that it falls within the advertised
Exactly.
location?
I have annexed, my lord, sketch. They did not controvert my affidavit in opposition. They did not file any reply controverting the stand of the, my lord,
So what?
that,
So, are you, do you
land
think that
resolution committee.
do you think that this court is going to dismiss his petition on the basis of this pleading when you have not brought on? Your basic case is it is beyond the advertised location.
Yes, my
The
lord.
only document which is required is the advertised location. That is why the petitioner has not brought in. No, you have brought in. No,
Advertisement.
it is seen from the materials on record. No, the petitioner. It is seen, it is seen from the materials on record that the rejection of the petitioner bid settlement, provisional settlement is on the ground
that the petitioner did not offer the land in the advertised location. However, most strangely, neither of the parties have sought for, have brought on record the advertisement for reasons best known. Taking into account the above,
Lordship,
list this matter only. The writ petition therefore stands adjourned, sine die, till either of the parties bring on record the advertisement.
my lord,
All right.
may I show, my lord, the annexure one? My lord, annexure one, page 16 of the writ petition, my lord. There is the advertisement, my lord, they have annexed.
It
They
is
have
not an
annexed, my lord.
advertisement.
My
You have
lord,
made
at
a
least
paper.
look
You
into it.
don't make an advertisement like that. You put it on the paper.
It is a e-advertisement, my lord. Page 16 is the advertisement.
You can't. Okay, hook it. It is seen when this court inquired with the advertisement, neither of the parties knew where the advertisement were. As such, it appears that neither of the counsels appearing on behalf of the parties were prepared. Accordingly, list the matter after adjourn the matter sine die to be listed only when jointly applications are filed before the score, before the registry for listing.
Lordship, I'll file the application, Lordship, enclosing the original copy of the
Not
advertisement. Lordship.
necessary.
Because
Because
they,
of
they,
you, they
they
have
may not
stopped.
file, they may
They
not
have,
file,
because of you, they have stopped. So under such circumstances,
because they will not come forward to file the application.
আগৰ
Lordship.
অৰ্ডাৰটোৱে লিখি থাক এই চাইনাইডাইজ যে কৰিলো
Yes, Lordship.
cyanide.
This will be obliged, Lordship.
May please, sir, lordship, my lord. My lord, here, my lord, the pleadings are completed, my lord. My lord, I pray for little accommodation for today, my lord, Mr. G.N. Sahibala in this matter appears, my lord. Now, today he is suddenly unwell, my lord. He could not come to the court. So therefore, my lord, the matter fixed on a particular date. Here, some hearing also requires, my lord. And pleadings are completed. We filed the affidavit and they filed the reply also.
At the request of the parties, the matter stands adjourned to be listed on 9th of March 2026.
9th of March will be two days. First week of December.
6th of April 2026. Yes, none appears for the Filter Municipal Board. Yes, now you are appearing. What is your stand?
Lord, Lordship will find the order passed by the board. It's quite in order.
Huh?
Lordship, see at page 61.
8?
61.
Yes. You have filed the affidavit.
Lord, affidavit, my lord, they could not get the old records. My lord, if the lordship accommodate me for at least 3 weeks' time.
What is the matter about?
Matter, my lord, is small quarrel in between two brothers, my lord, regarding municipal sprawl. And petitioner has brought an allegation, complaint that the municipal chairman passed the order on the basis of an ex parte inquiry without hearing him. So in this view of the
What
matter.
order is being passed? Where is the order?
Order, my lord, page 1461.
61, your lordship will find the. stalls are
Annexure
settled
14,
between
page
the two
61.
brothers. In the middle, your lordship will find that.
As per the report of Sri Pankaj Singh, the
Where is
market
the appeal? Appellate order.
Yes, sir.
appellate order is page 70, my lord.
71. Page 70, my lord, 70. That is also adjudicated quite reasonable.
They have to adduce evidence, my lord, as regards if the matter is hard in between them, but before the authority concerned, after hearing both them, they will show their papers, original license, registration, this thing, man. These were not examined, petitioner not.
Now, what is the dispute about?
Dispute, my lord, there are three, a row, stall number 8, 9, 10, and 7. Petitioner, my lord, as per his statement and documents, that is, he is the original license holder and he was running this stall. Sometimes in the middle, he was ill So he, for time being, he handed over to his brother. Later on, the brothers taking the advantage of his illness, occupied the stall he was not vacating. So there was dispute between them and there was a settlement in the
So
market
the
committee.
question is, why on earth did you go to the municipality? You should have filed a civil court.
My lord, the civil creditors, they are not personal property, it is the property to municipality.
Whatever may be, are you going to say it is not a property, it is a right for you to own, use. The right to use is also a
In-
proper right.
Exactly, your lawsuit stand is correct, my lord. I suggested them, but the advocate concerned at Silchar suggested them.
I can't help him with that.
So they were
The
fighting.
fact remains, the problem, you see, these are question of evidence.
Yes, my lord.
Dispute between two brothers
Two brothers.
as to whether these brothers, whether it actually was given to by the municipality to the elder
Yes,
brother
yes.
or to the younger brother.
Exactly.
That is the issue.
Yes.
Now you have made the witness. The witness is the chief executive officer is the witness in that proceedings. The adjudicating. Isn't it, Mr. Lopez? So, how can I help you?
I was of this such opinion as your lawsuit suggested, my lord, thinking of, but as the matter was dealt in Silchar court, in trial court as well as
I
the.
think now with a stamp of approval given by this court dismissing your petition and thereby giving you liberty to approach the civil court, may compel that advocate to seek recourse to the civil court
This will do the purpose, my lord, but only thing I have.
without being influenced by the orders passed by the chief executive officer or the appellate authority. That is the only way out. You have made the witness. Tomorrow, if there is a problem with regard to your sale deed, are you going to go to before the register, sub-register and say, look, decide our title? Right to use is also a title.
Yes, yeah, exactly. So instead of mentioning the word.
They can go to the appropriate forum.
That is the only way out. Which are the shops?
7, 8, 9, and 10. That your lordship will find at page 61.
Heard Mr. M.H. Rajbor Bhuiya, the learned counsel appearing on behalf of the petitioner. Miss Udas, the learned additional senior government advocate appears on behalf of the respondent number 1 and 2. Mr. S. Dotto, the learned senior counsel assisted by S. Dotto. Counsel appears on behalf of the respondent number 3 and 4. 5, who appears? I have 3, 4, and 6.
Rita Devi, my lord, but she, our phone to request.
You are assisted by? Sir, R.P. Sharma, from the morning onwards, you have taken the senior designation for a ride. First, you make a mention in the morning saying, my junior has left without giving me the file. And the second, now you are appearing without a junior counsel. Who is your junior? Then it would be a collusion. Because he also appears for Silchar. And so appears and for respondent. The dispute in the instant proceedings, as would be seen from the materials on record, that in respect to is in respect to 3 stalls wherein licenses have been issued by the Silchar Municipal Authority, Silchar Municipal Board. Corporation. No, this was board then.
Yes, by then it was board.
Silchar Municipal Board, as it then was,
to the petitioner in the year pertaining to stall number 8, 9, and 10. It is alleged by the petitioner that on account of his illness, he allowed the respondent number 5 to use it. However, the respondent number 5 did not return back when the petitioner wanted, and as such, the dispute arose. The said dispute apparently is a dispute of a civil nature between the petitioner and the respondent number 5. Instead of approaching the civil competent court of civil jurisdiction, the petitioner approached the Silchar Municipal Board, the Chief Executive Officer of the Silchar Municipal Board. And thereupon, a decision was passed on 15 line, na?
Page 61, my lord. First order was
25 line.
On 25/9/2019 against the petitioner. Resultantly, the petitioner, being aggrieved, filed an appeal which was also dismissed by the order dated 10/2023 and as such by the present proceedings. The question, this court have heard the learned counsels appearing on behalf of the parties. The question which arises pertains to the right of use of the stall numbers 8, 9, and 10 of, what is that?
Silchar Municipal Board at Itkola Market, my lord.
At
Itkola Market, Silchar.
Goyangso Market. Between the petitioner and the respondent number 5. Such a civil dispute, in the opinion of this court, the Chief Executive Officer or even the appellate authority of the Silchar Municipal Board was not competent to decide. The petitioners would have been well advised to have approached the competent court of civil jurisdiction. This inquired with Mr. M.H. Rajbarbhuiya as to why the petitioner had approached the Silchar Municipal Authority Board. The learned counsel submitted that the same was done on legal advice, taking into account that the property belongs to the Silchar Municipal Board. It is the opinion of this court that the Silchar Municipal Board could have been at best a witness, but not an adjudicating authority in respect to a purely civil dispute within the ambit of civil dispute, which ought to have been adjudicated by a competent court of civil jurisdiction. Taking into account the above, therefore, this court interferes with the orders dated 25/9/2019 and 10/10/2023, impugned in the instant proceedings on the ground that the said authorities did not have the jurisdiction to decide. However, if the petitioner is of the opinion that there is a requirement for recovery of possession, the petitioner has to approach the court of civil jurisdiction, a court of competent civil jurisdiction. Accordingly, the instant writ petition therefore stands disposed. The dismissal of the instant writ petition shall not prejudice the petitioner if the petitioner approaches the court of competent civil jurisdiction.
Only thing, my lord, your lordship may be pleased to add 7 also. Stall number 7, 8, 9, and 10.
Any more stalls?
No, my lord, sufficient. Much obligement. 22.
Yes, what is this, Mr. Bhattakur? Oh, yeah.
Okay, it's not.
I believe in the opposition file. What is the stand?
We have said that he's entitled for 18 lakhs, 6,340.
Huh?
After verification, we admitted the amount of rupees 18 lakhs, 6,340. We say in a verification.
You want that money?
Yes, sir.
affidavit filed with respondent number 4.
Yes.
Claiming 18 lakhs. Take that money. You have more money.
He's claiming 23 lakhs or 24 lakhs.
But the
No, you take this money and remaining, if you want, you can go before the civil court. আমার order আছে নয়? একটু edit করেছে, paragraph number 4 and 5 put করি। Direction to pay within 6 months. So it is further observed that in respect to the remaining amount, if the petitioner have any grievance, this petitioner would be at liberty to approach the civil court, court of civil jurisdiction, if permissible under, otherwise permissible under law.
23.
You does.
Yes, my lord, I have filed the affidavit, my lord. On this date, my lord.
Arrest number 3.
What is that?
5 kilometer radius, my lord, as per the consideration.
Within 5 years, there are more than 90% non-beef eating people join. The renewal fees has been deposited up to a month only. No renewal application for trade license are pending. Unless they take effect, they have to be to the petition. No, it's okay. Let him give an undertaking that he is not going to sell beef.
If my lord not beef, then my lord,
Okay, no, my only question is, here, that is why I'm saying, you taking into account this, you file an affidavit, reply.
none.
Yes, my lord, admitted, my lord, 500, 600, 700 meter distance, the other religious persons.
Mr. Counsel,
Miller.
you want to run the restaurant?
Here, no restaurant, it's shop, my lord.
Shop.
Oh, I forgot. There is
Shop,
another.
shop.
The shop.
Shop for what?
For meat shop.
Huh?
Meat shop,
What?
beef shop,
Beef.
beef. I mean, look, last order kindly.
Change your profit.
Last order kindly, similar, page 30 minute, one paragraph.
Okay,
Page 30, 30,
32.
30, 30. Para 15.
Yes. Could not have usurped the powers of the computer authority as well as the other Christopher's completed. It will treat the. Now, as of now also, you don't have a license.
Yes, my lord, page 31, my lord. Submitted application for license, but my lord, this application is yet to be disposed of.
Now, what do you want?
My lord,
In view of this, how can you get it? Kali Mandir 30 meters, Shiv Mandir 300 meters, Durga Mandir 300 meters, Jain Temple 300, Hindu Harisabha 320, Namgarh 800 meters, Buddha Vihar 600 meters, 5 kilometers radius. There are more than 50 Namgarhs and various non-Muslims. Then can't help you.
Next week, my lord.
Isn't it the mandate of the law?
Yes.
You can't have it unless you challenge the law. Challenge the Cattle Preservation Act.
Section 8. And next week, my lord, any date.
Huh?
Next week, any date. My lord.
What?
And next week, my lord, matter may be urgent for the day.
I don't get you.
A matter may be urgent for the day, my lord,
Next
Mr.
week.
Next week.
Yes, next.
Okay. Mr. Counsel, Mr. Swain, appearing on behalf of the petitioner, submits that he would obtain instruction taking into account the stand of the respondent number 3 in the affidavit in opposition. First up, list this matter again on 19th of November 2025.
August.
24.
Your affidavit is not prepared. Affidavit is not prepared, so kindly fix the matter after 2 weeks.
Affidavit you are not filing.
A reply.
Matter pertains to what?
In a
Like for allotment in the new building constructed in long-term municipal, however, the application has not been taken up. for consideration. Have you taken up for his consideration?
Paragraph 9 of our affidavit we have said, we have undertaken a selection process, allotment process. Here were 193 applications came. Only petition number 1 took part in that process. Other petitioners did not care,
Did not?
did not take part. They did not participate in the process.
How many petitioners are here?
They have not.
Petitioner number one participated.
Only,
Then,
only one participant, but the, total.
did you give it to him? No.
Total 76 shops are there, rooms are there,
Uh.
and 193 applications we received.
Uh.
Already 76 allotment we have done, but kindly come to page number 45, para 9.
It's okay. We do one thing, we dismiss your petition. Huh? Tomorrow. Tomorrow 10:30. That's 2 o'clock. We dismiss. Enough of enough. Taking into account that Ms. Srinath has expressed the urgency in the matter and in spite of opportunity, the petitioner have not filed any reply. This court would take up the matter for disposal tomorrow at 2 p.m. Yes, any urgent matter? Right, it is some full court meeting.
35 to 37.
Oh, this three matter.
This deputy commissioner has filed an affidavit, your lordship. The commissioner, your lordship, sorry, commissioner food and public has filed an affidavit today. We received the copy. Commissioner. This,
But Commissioner of Excise.
no. Commissioner of Food and Public Distribution, Consumer Affairs has filed an affidavit today, your lordship.
This is for that epoch. thing, huh?
EPOS, your lordship. They filed an affidavit today. And so we'd like to take the instruction whether the petitioner agrees with what the stand they have taken, because they have said until and unless a license of other fair shop price are cancelled or revoked, then only the names of the petition will be entered in that database, your
But
lordship.
that can't be.
That's their
Because
stand.
otherwise, once you are having a license operating,
Yes,
the PDS distribution of a license, what do you call there's a particular targeted order, na?
oh,
The
yes.
targeted order requires that EPOS machine. And this EPOS machine is further required for the purpose that to look into it, that as to whether there is a proper distribution of the state largesse. Well, continuing with his license, how can you say that you are not going to give?
Most probably. That's, that continuation license, that statement has not been made in the writ petition. That is an instruction I will take, whether you are continuing the license or not. If they're continuing, whether this stand cannot be taken, accepted, your lordship.
That is the,
That's on the issue, your lordship.
it is seen that the commissioner, food and civil supplies, huh?
Commissioner, Food, Public Distribution, Consumer Affairs and Legal Metrology.
So and so have filed an affidavit in opposition pursuant to orders passed by this court. So Mr. R.R. Gogoi, appearing on behalf of the petitioners in the batch of three petitions, submits that he would obtain instructions if any reply is required to be filed. And if required, the said reply would be filed. List the matter on 10th of December 2025. In the meantime, reply be filed, if any, by 8th of December 2025.
Published.
Yes, Muslim Ali, Mr. Deedar, yeah.
We have filed our reply, lordship.
Pleadings
So,
completed, madam.
any other
We are
difference?
challenging the termination of contract. We have terminated, we have issued a fresh tender for the balance work. Now it has been issued to a third party.
So, lordship, last occasion, lordship, asked them to
Reason for
publish
doing
the
so is that
record,
the next time
the name of
respondents
third party.
after termination have issued a letter of intent to a contractor for completion of the remaining part of the work. And if an interim order is not passed protecting the petitioner from the imposition of risk and during the pendency risk, the petitioner would be triggered. It's not to impose the risk in the finalization of the present dispute. Now what do you want?
for admission any,
When?
any confusion.
Lordship, only one thing, Lordship, in the affidavit, they have taken stand that the remaining work has been allotted to any other party. So they may be directed to place on record the name of that Lordship party.
Why?
Lordship, that's because if required, we have sought for a Lordship any relief against that Lordship party also.
No. Because of the fact that, are you going to do the work?
Lordship.
I asked a specific question on the last occasion to Mr. Dida. Are you going to do the work? If you're asking for termination, he said no. Then why you are asking them? Only issue therefore is whether the imposition of risk and cost is proper or not.
No, any, on any day.
That will be the thing, so that he is not burdened with the penalty.
You want the name, go and find out who is working. You get it?
No, nobody is working, Lordship. Yeah, I have instruction, nobody is working at the site.
So let me have it after 6 months. In the meantime, you'll have it, find it.
Lordship, as per Lordship convenience, Lordship.
Huh?
As per convenience of the court, Lord.
So taking into account that the pleadings are complete, I'll list this matter on 23rd of January 2025, 26, 23rd. On 22nd of January 2026 for final disposal at the admission stage. Interim order passed earlier shall continue till the next.
29.
Late cases, the Lordship. The matter pertains to non-payment of contractual bill, my lord. But
Before you start, madam, but we have filed the affidavit yesterday, madam.
we have received that, my lord. We
You
have,
filed affidavit.
we have received the copy, my lord.
Oh, come on.
Affidavit we have received, my lord.
It has been submitted that an affidavit has been filed on behalf of the respondent number
2458.
2476.
5 and 6. However, the said affidavit is not on record. Urgency before this year or next year?
No, my lord, this is, my lord, because it's non-payment, my lord, we have to receive the money, my lord.
Okay. List the
Yeah.
matter on 1st of December 2025 for admission along with the said
My lord, next week if possible, my lord.
Huh?
Next week if possible, my lord.
Let?
Next week, my lord.
Why? You have approached this court in 2025.
Yes, my lord. And affidavit.
Item 30.
Affidavit.
So means me trying to dispose of early have really spoiled some aspirations of the law. Yes, madam.
My lord, in this case, the respondents were supposed to file affidavit, my lord.
We have sent up the vetting, we're filing with the district, your lordship.
You have filed the affidavit.
No, we have sent it for vetting, your lordship. We'll filing with the district, taking with it.
Well, it's not done, it will be filed immediately, taking. Okay. The affidavit which was supposed to be filed on behalf of the respondents have not yet been filed in spite of this court directing so. In terms with the order dated 15/10/2025, Mr. R.R. Gogoi submits that the affidavit will be filed positively by next week. List the matter on 26th of November 2025.
31.
31, 32, same, my lord, similar.
Herein the respondent number 7 and 8, they have filed affidavit. I have also filed my rejoinder in respect of affidavit of respondent number 8.
Filed
7 and 8.
PNRD?
PNRD
PNRD affidavit filed.
Yesterday,
But I want to make my counter, your lordship, with regard to the.
File a reply.
Yes.
Mr. So-and-so, the council submits that the petitioner would like to file a reply to the affidavit filed by the PNRD department. When? What is the matter about?
Settlement of market, your lordship.
Stay,
There is no stay.
our stand is that it's on private patta line.
you have urgency?
Urgency.
No urgency.
Urgency is,
There or not?
urgency is there, your lordship.
No, I'm asking you, urgency is there. Grave urgency?
Grave,
Not there. List the matter again on 28th of January 2026. In the meantime, the reply be filed.
34 and 35.
Yeah.
Regarding my non-registration of
Oh,
my.
this one.
Yes, my lord.
Have affidavit been filed?
Yes, yes, my lord.
You have filed your reply?
In one case, we have filed my reply, my lord.
One too, it was at the stage of hearing. I was deciding it.
Yes,
The other is as regards why the permission, no objection
ma'am.
was not granted.
Yes,
That
madam.
is the second.
Second, my lord.
This has been done at the behest of my putting that query, that
Yes, ma'am.
without a challenge to the circle officer's rejection,
Yes,
you
yes,
could
madam.
not.
Yes, ma'am.
So there is an urgency in
Yes,
the
ma'am,
matter.
because we are unable to run the.
We have it on, you are for the forest. You have filed your affidavit, na?
Revenue department has.
You are revenue. You have filed the affidavit.
Revenue, no, ma'am. Revenue. no.
This is, this is.
DC has filed, madam. DC has filed. DC has filed the affidavit, madam. DC filed.
Your DC affidavit will be enough, Mr. Borbuzari? Chalo. He has an urgency. We take it up next week. Okay. List the matter on, taking into account the urgency shown, list this matter on 25th November 2025 at 2 p.m. for final disposal.
Oblige, Lord.
May it please, your lordship. My lord.
Yes.
My lord, pursuant to my lord, tender notice, my lord, I have participated in the tender, my lord, and one of the tender condition is that, my lord, the tender have to, my lord, submit a, my lord, solvency certificate, my lord, of 3 lakhs, my lord. And I have submitted the solvency certificate, my
Matter.
lordship, my lord.
Where you lost your, I
Yes.
passed an interim order, you failed to, got it extended, isn't that?
Lordship. Therefore, my lord, this matter has been fixed on to them, my lord, considering the.
Respondent number 4 has filed the affidavit.
No, my lord.
However, after the regular review order, the respondent, five respondent who has been now, it is added, and by amendment, the elected work in hearing. The essential item, food items for us.
The question is, some RDB was appearing on behalf of the respondent number 4. Did the respondent number 4 file the affidavit or not?
Our mother, the getting this is detail will be.
IAS, Niki?
I have to, no, my lord, only. All IS are disposed of, my lord. All IS are disposed of.
I will dispose of.
All IS, my lord.
Who is respondent number 4? Vivek Transport.
Lordship.
So you say the stay vacating application be treated as your affidavit? Okay. It has been submitted by Mr. R.P. Sharma, the learned senior counsel, appearing on behalf of the respondent number 4, that the affidavit, that the stay vacating application, the contents of the stay vacating application be considered to be the affidavit in opposition on behalf of the respondent number 4. Mr. So-and-so expresses urgency in the matter as there is no interim order. So accordingly list this matter on 27th of November 2025 at 2 p.m. for final disposal. Senior counsel, I don't grant adjournment. No accommodation.
Very long, the little 28 or 26, 26.
Mr. Sharma, there cannot be an accommodation for senior counsel. Don't violate today the 3rd rule. First rule you have violated in the morning, second rule, death time, and now this is the 3rd rule. And see, and kindly see part 3 of the Bar Council rules. These are rules made under 16(3). No, don't. This is the 3rd. Anyway, any urgency? No urgency. Mr. Sen, your matter should be taken up at 10:30. Tell me, what is it?
Item number 54, Miller.
What has happened?
Day after tomorrow, Miller.
No. Oh, yes. 54 day.
42, there is an interim order till today, man.
Okay. Get the interim order extended. Anybody's interim order is there.
Item 55, Lordship, day after tomorrow, Lordship. Item 55, Lordship, which was regarding the
Mr.
tender.
Sen's matter, I'm 50 day after tomorrow. Do you know why?
My lord.
Because I'm not sitting day after tomorrow. You want that, you take it. Okay.
Item number.
But any date, your lordship is sitting, Millard. I'm sorry. Your lordship did not indicate that, Millard.
Anyways, get your date.
My lord, item
But there is
50,
some urgency,
my
right?
lord,
My lord,